specific non-exclusion of the word of Limitation Act, then this shall follow. These are the two limits, my lord. And apart from that, the constitutional guarantees under Article 21. That is the main premises of the case, my lord.
Lordship, that is precisely the point. What has happened here is, Lordship, in one particular case, though the previous matter, I did not file my objections. The court was pleased to allow the continuation of 150 days. Basically on Article 21. But if we construe that quickly, Lordship, so far as the exception is concerned, the proviso specifically states that the High Court would not condone the delay beyond 90 days. It has to be, appeal has to be filed within 30 days, and after 30 days, till 90 days, the High Court can condone. The point is very specific that beyond 90 days, the High Court cannot.
There are many statutes, inbuilt statutes, like the Arbitration Act.
No, sure. There are.
But there will be a difference here. Personal liberty will be concerned.
No, sure.
So we cannot be oblivious of those issues.
No, sure. That is.
Therefore, very position to expire.
Yes, Lordship.
Okay, this is a special enactment.
Yes, my lord.
So otherwise, there is a special period of limitation.
Yes, sir.
Ordinary period of limitation is 30 days.
Yes.
Extended period of limitation is
Yeah, ma'am.
within which it can be entertained. Under the proviso to subsection 5 of section 21.
Yes.
So it bars the remedy of appeal after 90 days.
That does.
And this aspect is associated with the right to personal liberty under Article 21. And this is with regard to matter of rejection of bail. So how the fundamental right protected under Article 21 has been denied by virtue of this special period of limitation regarding filing of appeal. That will bar you from the remedy of appeal,
Yes.
which is always a creature of the statute. But that will not debar you to seek protection of your personal liberty by filing a fresh application.
Agreed, madam. Agreed.
The Supreme Court has laid down the proposition that when a special enactment provides for a special period of limitation, right? Even we, Supreme Court says, under Article 142, by virtue of Article 142, cannot bypass that period of limitation. So it will debar you from the remedy of appeal, but it will not debar you.
My lord, I can always
But-
file a fresh bail application
Yes.
with a new ground. I
Yes,
agree to that.
an appeal is always a creature of the statute.
I agree to that. But-
Now, there are divergent views of the
Different.
different high courts.
Also, the Supreme Court in one of the judgment has referred back the matter saying that the condonation won't be a aspect. You continue with the merits of the appeal. That is also there. Sajjal Avasti judgment is there.
What does the,
If I may give it.
yes.
Lordship, a series of,
There is a settled proposition that
yes, sir.
something
But
bars
consider,
the remedy, but that does not bar the right,
uh,
prohibit the right. So prohibition of right
my lord,
to exercise the right to personal liberty is still available.
I agree, my lord. It's still available. I can still go before the special judge and with new grounds. I can
Yes, what-
find it.
Yes, Mrs.
That was precisely my argument before the division bench last week.
But my lord, considering the judicial trend that has been made,
Why this appeal would be more material, this reference would be more material. You see, we are now thinking in lines of bail. What happens if there is a delay in filing of the appeal against conviction? Would you still shut out the person only on the ground that there will be no appeal? And therefore your conviction is there and you may face sentence of death or time imprisonment?
That is the broader implication, Lordship, yes.
This is non-obstante cause.
if lordship is with me on page number,
Appellate provision is there for.
Yes,
appeal
bail,
and for
bail
bail
as well as for pending the appeal out.
Can we have a distinction that when it comes to bail, he would not able the remedy of appeal? And when it comes to appeal against conviction, then that can be, same provision will be read.
It cannot be that much.
There is only one provision. There is no distinction in the provision whether it's an appeal against rejection of bail or non-granting of bail, or is it an appeal against a conviction order? If it's a conviction order, the ramification will be immense.
Lordship.
Ramification will be immense. So if we answer this reference, we cannot confine it to a bail because 21 is the.
No,
general-
it has to be one.
Yes,
It has
It has to be one answer.
It has to be one.
Because I fully agree with my brother, Chaudhary, where the bail provision, if it's answered against he has the right to again file a press, maybe press grounds are there or not, but he's not totally left remedialess. But if it's an appeal
That is
against
only
a
in
conviction
respect
order,
of bail.
where the general principle is to have a lenient
yes,
so far
but
as admission is concerned.
The Lordship has to look into that also.
Or the Union of India, who is the author of the law, can always make an argument that though the provision of bail is standalone provision, but it can be distinguished for the purposes of appeal and bail. You will still raise that plea.
Not in the context in which the statute has been drafted. Perhaps not. Not in the context of the statute The statute does not make any distinction.
No, not that, but
Yes.
at an appropriate level.
No, that can be argued, Lordship. That can be argued.
My lord,
Because there in an appeal, Article 21 will be more strictly applicable than in a bail where he has got a remedy.
my lord, in the High Court of Jammu and Kashmir, they themselves have gone with against this provision of 21(5) and the delay has been controlled for them. My lord, if the agency is going for the condemnation of delay,
In that Jammu and Kashmir case, it was an appeal against conviction.
appeal against, yes, my lord, against bail, against granting of bails, my lord. They have gone for the rejection of bail orders.
But
I
the
would just like,
statute has got another issue. There are two provisos.
Yes, my lord.
yes,
The first one says regarding, it doesn't end at the first one. Please read the first proviso.
Yes, my lord.
First proviso.
provided that the High Court may entertain an appeal after the expiry of that period of 30 days, if it is satisfied that the appellant has sufficient cause for not preferring the appeal within the period of 30 days. So that is still 30 days.
Then,
Then, provided further that no appeal shall be entertained after the expiry of period of 90
90.
days.
But my
That-
lord,
That makes sense.
to this argument, my lord, section 29(2) of the Limitation Act says that if a special provision is there and it does not specifically exclude the Limitation Act and the lawmakers have not included the word excluded in the limitation, then my lord,
what is the decision in 34 of our Petition Act?
my lord, that
full bench?
unpopular construction case is
The
the,
full bench?
so my lord, they have not, my lord, that is again a civil matter. my lord.
No, we just want to know, which.
My lord, in that matter, it was, they say that won't be condoned. 34 Arbitration Act won't be condoned. Yes, ma'am.
And subsection 4. Right.
Yes.
This is an exception to, subsection 4 is exception to subsection 1. Because otherwise, what kind of order, an order of bail is? Interlocutory?
Interlocutory.
It's a final order. Bail, final order.
Yes.
It's a final order.
Because subsection 4, that is why it has been incorporated. I think first judgment on NIA Act from this court.
My lord,
That,
trees,
that full bench worship was a part of it.
No, no.
others, my lord,
That is another one. But first judgment on NIA Act, I think under for subsection 4 of section 21 is from this court. NIA case number 1. Find out it is an interlocutory order because this provision, otherwise not being an interlocutory order, that has been interpreted that bail, perhaps bail is an interlocutory order. That is why this exception under subsection 4 has been carved out.
It is the case of, perhaps it is the case of that RS Khan, Redaul Hussaini Khan.
yes.
I go through.
Lordship, otherwise 378 of the Code of Criminal Procedure, that also prohibits filing of appeal against acquittal beyond the limitation period. My lord, but that is also yet and again condoned.
No, because when it's CRPC, then section 5 of the Limitation Act can always be invoked.
But my lord, here no exclusion of that word is there that this cannot.
But that is
Conclude.
also the Limitation Act will apply because there is no exclusion clause.
My lord, same here. There is no exclusion clause of the Limitation Act.
Perhaps
Here it is.
the second proviso.
Provided that.
You cannot equate this with the CRPC.
No, my lord, I'm. for
This is a self-contained code. It has got a limitation. And how it has been explained, if you go by strict interpretation, provided further the no appeal shall be entertained. We use this as shall.
My lord, this act perhaps is a self, but it is always dependent on the other sections of the Code of Criminal Procedure.
No, these are all
Procedure.
sensitive views. We'll hear this matter in detail.
Because it just lays down the procedure, nothing else apart from the procedure. And my lord, when it comes for technical justice versus substantive justice, the Court of Equity has always granted Article 21 priority.
In that case, Limitation Act has to be scrapped. Why limitation? Limitation Act grants a right if you do not file within time. to the other party. It'll be redundant. Not in all cases technically.
But my lord, where person.
Here you must still have a case, 21 is involved, we are concerned about that. But still in your case, the bail rejection, you can always file another bail application.
But my lord, considering the judicial trend that has been going with the passing of judgment by the different honorable high courts, there has always been.
But the order by which this reference has been made,
Yes, sir.
that order has cited very good reasons.
Yes, sir.
The requirement of completing an appeal within record time, or completing a trial within record time, those are considerations. It cannot be an endless process.
Only question maybe whether this bar will be applicable against a judgment of conviction.
Ambiguity is there.
If that ambiguity is there, if that is not applicable, then law is clear. Because it bars the remedy, but does not curtail the right,
In my case,
in your case,
I agree to that point.
right? But whether that will be applicable on all fours in case of an appeal against conviction, or against a judgment of conviction, or against a judgment of acquittal.
Yes, sir. Agree.
If that is not applicable, then
When someone is remedious.
so there is no bar for you to file a fresh application for bail on fresh consideration. Sometimes it happens all the critical witnesses have been examined or yet to be examined. That may be a consideration.
My lord, if we enter the merits of the case in this matter,
Influencing of witnesses also can be.
for a moment, if I may touch the merits, my lord, the accused petition has been behind bar for 6 years, 11 months, 10 days so far. And out of the 177 witnesses, so far only 34 have been examined in this matter. My lord, considering the charge sheet that has been filed in the year 2019 and only 34 witnesses have been considered, my lord, it's a long incarnation that she has already fixed. My lord, and the sufficient cause that requires for the condemnation of the lady was his father's death and the incarnation itself. My lord, if technical point be kept aside for a moment and considering the judicial trend that has been going in the entire country, my lord, such cases has been permitted, then my lord, my merit of the appeal would stand before this court.
We go to the merits only when we answer
I
the
agree,
reference
I
in
just-
your favor.
I just like.
Now we are not even concerned with the merits.
Yes, my lord, I agree.
We have to first answer the reference in your favor, then you make it a case of merits to get a bail.
Is there any authority on that point regarding limitation period for an appeal against the judgment of conviction?
Judgment of conviction.
That this limitation period will also apply.
So what this act is concerned of.
See, Mr. Singh, we are asking this, my brother is also asking, we are asking the question on two provisions. Number one, in the interpretation clause section 2,
Yes, sir.
we have the definition of the definition of force.
Yes, sir.
Now, if you look at section 13, it says, my esteemed brother said that this is a self-contained court. Now come to section 13. 13 says, notwithstanding anything contained in the court, every scheduled offense investigated by only by the special court. So therefore, they derive their power to try, not under the court, but under this.
Yes, sir.
And since the court is already accepted a proposition in this, therefore the procedure adopted in the court, that is CRPC, can still be followed.
Not be followed, then my lord, there's always a limitation.
Therefore, it says, see, how does it invoke power? Section 14 says, when trying any offense a special court may also try other offenses which the accused may under the court be charged. Therefore, this has precedence over the court.
Yes.
It can assume jurisdiction.
My lord, with regards to limitations, that is again a special statute in itself.
So here's the matter. But we are just thinking aloud if all this can be over if you take consent to go to the to file a fresh bail application and this reference.
My lord, that discussion I had on the last occasion with my client, with sense of long incarnation, some frustration has been offered, my lord. Now she says that at least an order of the court will put the matter to quiet.
So that ground will still be available if
Yes,
there is
my
a
lord, I
fresh
agree to that.
rejection.
But my lord,
You
with
can
regard
get
to
a rejection
withdrawal,
order and come back to the court.
Pending this
Within limitation.
adjudication, lordship, he can still file. Pending this adjudication, of the legal aspect, he can still file a bail application.
yes, because it has not been numbered and it has not been admitted, I may still file. My lord, this matter has already been filed for 3 months now, my lord. 6 years, long incarnation, my lord, again going back and filing of.
That's why when we hear it again, it will take some days. That's why we are thinking aloud. We are not suggesting anything, we are just thinking aloud.
File a fresh bail application, get it rejected, and come to us. Will not be required to answer this reference. We'll consider on merit. Provided it is rejected, it may be
Provided.
granted also.
Otherwise,
Yes, my lord.
you know,
Again, new
KM
grounds has to be carved out
he
here.
might be having a very good case.
Again, new grounds have to be carved out from my lord, because already.
It is behind the bars, what new ground? This is not anticipatory bail. Long incarceration, every day, 1 day, passing day is good ground. It's not anticipatory bail.
My lord, I have been just coming with this section because judicial trend across the country.
Now
has been
you
condoning such
take it practically, we'll answer it, but cannot be today. We'll have to have a detailed hearing. As fallen in the discussion, the aspect of conviction is also there. But this cannot be confined to only bail, because 21 is a general provision for everything. So if we answer, we have to take everything into consideration. That might take some time. So,
Do you have any idea about the decision in RH Khan? What points were formulated there and what points were decided?
RH Khan, my lord, I think I have brought that judgment. RH Khan. That was against my lord. That judgment did not follow. I have read that judgment that was quoted, but my lord, I have no idea. I have not brought it.
Because that was the first
I
judgment
keep to that judgment.
on subsection 4 of section 21. And there was elaborate discussion on it. Because perhaps that is why this word has been put there in subsection 1, not being an interlocutory order.
yes.
And an exception is carved out in subsection 4 for a special appeal only against an order granting or refusing bail. No other interlocutory order. No appeal will lie.
Against only interlocutory.
Yes.
That citation is 2013 2 GLR 493 equivalent to 2013 1 GLT 880.
It is specifically on 21(4).
I'll go through that.
No, regarding the limitation has been dealt with.
Gogoi, be requiring US an amicus curiae in the matter. Here we are, there is a reference where we are interpreting the provision of bail under section 21. That whether a bail can be, an appeal should be entertained after the statutory period of 90 days. The act says that no appeal shall be held. So there two ways of looking at it.
Two judgments is there also.
Not two, several.
Sure.
We will give you the reference. There are several cases. Uh, there are two ways of looking at it.
Yeah.
Number one, can the power of appeal be read that since otherwise to get a bail, one can always file a successive bail application. And therefore, here we restrain the application of bail for not more than 90 days. By holding that there is an exclusion of section 29, 2 of the Limitation Act because of the period of limitation already prescribed. The second view is that whether for the same provision of appeal, it can be read that even after the conviction, one will not have a right to appeal. Or we can carve out an exception that the appeal can be still preferred beyond the period of limitation. It can be entertained if it is a case of conviction. One may have a death sentence, one may have life sentence. Can that be can that be a way of reading the statute? Therefore the cases are available, but you have to do some research and address us on the power of the court to entertain bail, appeal against the order rejecting bail.
Mr. Singh, whether Sajal Avasti has been decided?
No, my lord, it's still pending. Series of petitions has been filed, my lord, and it's still pending.
So if I may, Lordship, perhaps Sajal Avasti is on 43B5.
43.35.
So the matter in the Supreme Court has directed the High Court to take up the. There was a case in our court, for the Honorable Chief Justice.
That is not under NI.
That is the UPA, UAP.
UAPA?
UAP. And the judgment in our High Court is not yet resolved. The arguments are over. Before Honorable Chief Justice.
Lordship, Sajal Avasti is an analogous matter with lot of matters that has been tagged together for the court. The only order that is produced in the Supreme Court website is of Sajal Avasti this matter. But if, my lord, we see the other cases that has been logged, they are under 21.5. The Rajasthan High Court, that Dargah bomb blast case that has been coming.
Prohibition of this court to take up the matter when the Supreme Court is in session of it.
So Supreme Court has left it to the High Court first to decide, and then it will come to the Supreme Court.
So what is observed till the next date of hearing, appeals, petitions preferred by the accused victims will not be dismissed on the ground that delay cannot be condoned beyond 90 days.
Yes, sir.
Meaning thereby this is
So,
subsection 5.
yes, ma'am. Even subsection 5.
That this appeal will have to be kept pending. That cannot be answered.
Yes, fine. Part of this order should not be dismissed on the ground that delay cannot be condoned 90 days. Whether it is with, should not, whether we can decide it.
But prohibition is not from deciding. It is not to dismiss.
But dismiss is a reason. But we hold against the appellant, it will be dismissed. And Supreme Court says
Not to.
should not be dismissed.
That is again creating.
If the reference goes against the appellant, result is dismissal. And Supreme Court has observed should not be dismissed.
It is creating conflict.
Which song? One way flight to Venus.
Lordship,
1 week, 30 days. Lordship, otherwise this Supreme Court matter is also fixed, I hope next week. That is what it shows on the bill. मला नव्हतं नसतो ही दर्गा केस तो असले राजस्थानाला तो रिव्हर्ट बॅक करू तो कोणीही असतो सर इट हॅज बीन लिस्टेड नंबर्ड ऑल्सो but अपना इधर इसको लाच But in fact, 4 days back, Gujarat High Court has also passed a judgment in this matter, condoning the delay, considering Sajal Avasti judgment that has been passed. That is also there, my lord.
Right, the appeal will have the freedom to give yes or no. It's only one way road. Not a decision in appeal there.
Page 69 is there.
So the problem is that this
I understand,
needs
but-
to be answered by, in a reference by a full court. If it was, one view was taken by the division bench and matter proceeded, the confusion will not be. But
Agree.
if it's by a full court, that will be the law of the land.
Hello.
There may be divergent views. One may be accepted, one may not be accepted. But once the reference is made and once it is answered, that will remain.
Agree. निकाल दो ठीक है नहीं रिवर्ट बैक कर ये रिवर्ट का सिंपल This one. वो डिफॉल्ट हो गया Yes, ma'am.
I was suggesting, tenth of next month, if it is convenient for the tenth of, June, or should it is convenient? Then let it be on ninth motion.
Used.
We don't want to be on a Monday and a Friday.
No, should, in fact,
Monday and Friday will be virtual from a short time.
that I will say. Tuesday perhaps we can be here. Okay. Because this case will require that we be here.
This Farhan said is against conviction.
Against conviction. Bombay Act.
Okay.
Thank you.
Dismissed.
Great regret. I have to mention item number 10 of today's list. It's a matter of 2013. And after 2013, the brief was taken back in 2015. And thereafter, the matter has come up for hearing on 2022. When we thought that the client already has engaged someone else, but when it again came on 2025, I had written to the client that we are not going to withdraw this matter. So yesterday evening, they provided the certified copies because the licensing officer and as well as the company is also not operational as on date. And so they could not pursue the matter diligently.
Fitting is not going to enter. Into it.
Manner. Otherwise, I got the brief yesterday evening only. That's the problem.
Being on behalf of the appellants for 11 and 12, my lord. The sole appellant expired, my lord, few days back, my lord. Yesterday, last night only I came to know, my lord. So, my lord, implement petition. I have taken the concern of the other side also, in them also, my lord. PK Roy Chaudhary is appearing on behalf of the respondent. Yes, my lord.
Therefore, you pay for it. Fee of, fee.
Yes, my lord.
been trying to give a short time. You get after 2 weeks. Yes.
My lord, one unusual prayer, your lordship. As regard item number 9, very old matter, my lord. Earlier matter was handled by my lord, now he has been elevated. My lord, so far as petitioner and respondents, my lord, I am told that some has expired, but I don't have a confirmation, my lord. Can it be, my learned friend is also, my lord, that in COVID, perhaps one respondent died, my lord. Sole respondent. Possibly, madam. Can it be taken up 2 weeks, madam? In the meantime, we will obtain instruction regarding their.
No, you have to tell us whether they have died or not.
Madam,
You see,
that is-
once we record.
We have
that
written,
they are discharged
no,
of,
madam, we have written to the client, but I have not get that confirmation.
the hearing. Unless a specific statement is made, discharge of.
May I say, my lord,
Even though-
can it be taken up next week? In the meantime, we will try to get the information, confirmation. If confirmation is not coming, then your lordship will hear it.
See. I we are not entertaining that, we are not trying to entertain. Is too simple. It's a topic. He appears to be. He does not say that.
He is saying,
My lord, yesterday I am informed by the,
You will tell us, the court and discharge of the, on the order principle from any.
in respondent master, he has signed. Respondent, my sole respondent.
You are appearing for the.
For respondent.
If you have to discharge your burden, otherwise you will have to continue to argue the matter.
For rest. Here, we are saying the appellant also died.
that not confirmation,
Not confirmed.
possibly, my lord.
We are not bothered, unless you tell us, you can get the information and tell us, because once we record it, there's a limitation and all. start
Yes,
with that.
definitely. Question of limitation and
We are not entertaining,
So lordship will take up on Wednesday, my lord. Wednesday, my lord. Or hearing it Thursday, my lord.
Thursday. Oh, no, holiday.
and, this respondent has died.
I am informed yesterday by the trial court. Okay, possibly he has died.
Who has died?
Respondent number 1. The sole respondent.
No, there are 5.
The proper respondent is my not here.
Performer, my lord. One
I'm appearing for the sole respondent number 1.
respondent number 2, he also expired, my lord. Performer.
Yes, Thomas, in the.
2 and 4 already struck off, my lord. Tomorrow.
I'd like to mention item number 8 with the consent from the other side. Can I keep mind 8,
Struck off.
item number 8. I'm for the previous respondent, respondent number 1. As my senior is on bereavement, your lordship.
Order again, the shop of the activities in Tribunal.
Eight, 9, or any date.
Six 2020.
Your lordship. And this to mention item number 5.
Right.
It's on the end.
Till we look at the record, we're not examining.
Appeal is otherwise already there. My lord, on 19.
We take it up. You will refuse the adjournment.
So in fact, I would also require some time because I also have been recently engaged. I have the copy of the appeal, but lower court records I have to reconstruct my lord.
There's a, order of this court. Look at the year 91 or something. What's this really can? He said that once somebody appears,
He's supposed to, my lord,
he is supposed
be conversant with this, my lord.
he's supposed to have instructions.
My lord. I have instructions, but then the relevant records are actually
Just
somehow not handled now.
Two and four,
No, these are not recorded. That's the difficulty. What call the. So for 3, 5, and 6, they are ex parte.
and two and four is stuck off, man.
2 to 4 are stuck off.
And one my learned friend is saying, correct,
Respond number 2.
two is struck, expired, now it is struck off, my lord, two and four.
No, that is performer respondent.
Performer, but so far as one is concerned, my lord, my learned friend as per his instruction,
We only record that. Who is that? If you don't get it recorded, the difficulties arise.
true, my lord. Appellant also, my lord, I have no inquiry.
The appellant and the respondent. Therefore, adjournment is made with the consent of the other side. Matter stands adjourned today. 2 weeks. I got the copies, that's it. That's. this order sheet,
My lord.
we find that issues have already been framed
Yes.
and that framing of issues were framed on 16/12/2020.
Yes.
The issues framed, did it not have the issue on counterclaim?
Actually, the Lord Council ignored that, my lord, overlooked them.
But then we can't help it. If the issues are there, court fees have been cut and you have been given a copy of the counterclaim. But after 5 years, you can't come and say that I don't know about the counterclaim.
One order, my lord, kindly see, my lord. It was order dated 26/8/25, my lord. Order dated 26/8/25.
26,
8/25.
25.
On that date, actually, case was fixed for judgment, my lord, but the honorable court, my lord, finds that the, my lord, regarding the WS part.
Yes,
Then, my lord, matters,
this was filed almost 5 years after the counterclaim was filed. And the PWs were examined, the issues are there, PWs were examined.
yes, evidence is over, my lord, evidence is over. Evidence is over.
You don't say that the counterclaim did not come to your notice. And how can you lead evidence without knowing what issues you have to lead evidence on?
That is, court also, my lord, never fixed the matter for, my lord, WS, my lord. That is also there, my lord. Now only, my lord, petitioner may not require to file additional evidence after filing the WS, my lord. In the, my lord, order dated, my lord, kindly see page number 3, my lord. In the
Page number?
page number, serial number 3, page, in the order sheet, my lord. Yes.
Yes.
Order dated 23/12/19, my lord. 23/12/19.
Yes.
In this order also, my lord, the defendant number 1 to 6 submitted written statement, furnishing copy thereof. There is no mention about the, my lord, counterclaim, my lord. Actually, the respondent number, defendant number 1 and 2 6 submitted written statement, counterclaim, my lord. There was no separate counterclaim. It was written statement, counterclaim. I think from that, my lord, there are never mentioned about the, my lord, counterclaim, any order.
No, but you are having a copy of the written statement. How would that prejudice you? You see, you can't say that you were not aware of the written statement come counterclaim, you were not aware of the issues framed, you are not aware of the nature of evidence you have to lead. How could you lead evidence without looking at those things? Can it be expected that a lawyer will draft an affidavit for PW without reading the written statement? So he does not even know how to deal with the denial.
Lapses are there on the part of the, my lord, engaged counsel, my lord. Is there, my lord. Honorable courts also find difficult, my lord, to pass judgment, my lord. And that is why my order dated 26/8/25 was passed, my lord, and the matter want to hard on the issue of my lord WS, my lord, not file. The honorable court also find difficult to pass, my lord, prepare judgment. That is why my lord order dated 26/8/25 was passed, my lord.
26/8/25.
My lord. Alia, I may not refer, my lord. Today is fixed for judgment. On appraisal of the record reveals that the defendant submitted written statement along with counterclaim, but the plaintiff did not submit any written statement against the counterclaim. The record further reveals that after filing written statement from counterclaim by the defendant, the suit was fixed for settlement under section 89 of the CPC. Instead of for filing written statement against the counterclaim, hence I deem fit to have the parties on this issue.
Oh, it's always will have to dismiss this application. If we come to page 39,
My lord,
paragraph 10,
my lord.
on a perusal of the case record, it appears that there is no date for filing written statement against counterclaim, and during that period, COVID-19 pandemic struck. Issues are framed on 16/12/2020 on hearing both sides, and issues both on plaint and counterclaim are same. Thereafter, the plaintiff side adduced their witnesses. The witnesses were cross-examined on counterclaim. The defendant too adduced some witnesses who were cross-examined by the plaintiff side. So there was cross-examination on counterclaim.
Yes, everything was there, but
Then
WS.
also you don't realize. If you've been cross-examined on counterclaim, then there's nothing remains. It can't allow you to file your witness statement, accept your witness statement.
For the fault of the my lord, youngest counsel, my lord, now the my lord litigant. But admittedly, there is some lapses on the part of the my lord youngest counsel. That is there, my lord.
He's the counsel who is still appearing for you. You have not filed any complaint against
Yes,
him
yes, that
that
is
he
there.
will misconduct.
Is still repairing. It may not be delay, my lord, but only my lord WS will file and thereafter, my lord, this argument will be, my lord.
No, but the details the entire evidence. You'll have to start. If you file a written statement, there has to be a reframing of issues. This is a suit of 2019.
The lordship may clarify on that aspect that no further issue will be framed, my lord.
No, we can't do that. How can we curtail the right of the court if the court wants that issue is to be framed? Can the High Court say, no, don't frame an issue? You can't do that. The every person by your written statement will not be you. It will be the plaintiffs who will be, defendants who will be aggrieved by the written statement in counterclaim. Will you not want any additional issue to be framed? How can we stop that? Now, how can we say that the evidence which is led by the parties will cover the counterclaim when you have not filed any evidence on counterclaim? That's something we can't do. But you say, petition. Next part. Agree by the order dated 13/2/2026, passed by the learned civil judge within bracket senior division bracket close Bopeta in BJ case number 205 of the 2025, arising out of TS 52 of 2019, by which the said miscase was rejected. From the petitioner, who is the defendant in the said suit, has filed this application in Article 227 of the Constitution of India. The learned counsel for the petitioner has produced the entire certified copy of the proceedings of TS number 2019, pursuant to order dated 18/5/2026, and he has submitted that on, as per order dated 23/12/2019, the learned transport had recorded that the dependent numbers 1 to 6 had filed the written statement and furnished a copy thereof to the learned counsel for the plaintiff. It is submitted that though the written statement contained a counterclaim, but the filing of the counterclaim was not reflected in the order dated 23/12/2019. No opportunity was granted by the said learned court to enable the petitioner plaintiff to file his written statement against the counterclaim. It is further submitted that after both sides had examined the respective witnesses, the argument in the suit was heard on 25/7/2025, and the case was reserved for judgment on 26/8/2025. Delivery of judgment on 28/6/2025, it is submitted that the learned trial court, on observing that there was a counterclaim against this new written statement, was filed. The learned trial court took into account that after filing of the written statement, matter was fixed for settlement under section 89 of the CPC. Instead of date for filing of written statement, the court was inclined to hear the parties on the issue. Thereafter, on 29/8/2025, the petitioners took an adjournment, and on 2/9/2025. The petitioner filed petition number 1942/2025. Paying for under section 151(60), paying for acceptance of the defense statement against Gauhati. Accordingly, Ms. J case number 205/2025 was registered. Next unit. On hearing. The matter. Rejected. You said Ms. J case number 205/2025. By order visit 13/2026. Rejecting the said petition. The matter was fixed for argument on 31/3/2026. And thereafter, the matter was adjourned again to 22/5/2026. Therefore, adjournment made by the petitioner. The issue is, what is it time for? If you notice returnable on the date after COVID, the returnable on 24. Petitioner shall take steps in course of the day for the purpose of notice and be responding by speed of PTD. Also the petitioner is at liberty to collect the postal receipt number and the postal fact report prior to the notice of mistake. Next. As the cases which are argument, what is the last date? Also in 22/5/2026. Court is inclined to provide that not fair for adjournment date by the petitioner printed. The learned civil judge in bracket senior division bracket goes Kolkata requested to adjourn the proceedings of PS number 52 of 2019 till up to next day. Okay. Make it 12 of 5. 12 of 5. It's 12 of 5. That's 12 of 5. When it's needed, is the petition. Don't have anything. So, PS number 15/6/2020. Make the return of the date of principal. Elected or distinct will be 22. If it takes steps today, fine. The returnable date is 19th of June. And we are requesting the trial court to adjourn the matter till 22nd of June. You file a adjournment petition and an application. Fine. In fact,
Obligation.
next week you produce it again.
Right.
My senior is coming.
After something.
Also, in item 6, we were supposed to file, in item number 6.
Hmm?
In item 6, we were supposed to file 3 applications. Applicant number 1 had died on the last occasion. We had filed it yesterday only, Lordship. It is not on record, Lordship. The matter will be posted after 1 week, Lordship, because since the petitions are not on record.
In fact, yesterday. Item 6. So the representative. Just putting out for the appellant submits that respondent number. Who is died?
Applicant number 1, Lordship.
Appellant number 1 had died and an application for subscription was filed on 20th.
20th, Lordship. Yes.
The application is not on record. So the phone registration is very intact. It's an application on record. It's for 25/5/2026. 25/5.
Obliged, Lordship.
But the appeal is otherwise already admitted and issues were also framed on 2/9/2015, the substantial questions of law. Then it has come in orders, my lord, because under the circumstances that we had to appear suddenly, my lord, is that the court indicated that there was a default on part of the appellants in appearing and it was to be dismissed if nobody appeared on our next day. So suddenly we had to put our appearance and I did not have the full papers also, my lord, but then in that emergent circumstances, I had to, my lord, suddenly appear in the matter. Now, the issue is very simple, otherwise, my lord, it is that I was given my right title and interest, but then the recovery of possession was not granted by saying that the defendant respondents herein are occupancy payments, my lord. So the exhibits particularly, my lord, which shows their right, my lord, in the writing Khatian as a occupancy tenant is, I still have to look into that, my lord. And the issue framed is also precisely that, whether a Basti land can be covered under, my lord, this Assam temporarily settled tenancy,
Never removed.
my lord,
You see, the Rayati Khatian did not translate into a record of right.
my lord.
So unless the government, what you call, alters the position,
my lord,
you remain to be a occupancy tenant.
my lord.
That even if the land is cost in a basti land or the status of the, you derive your possession right on the virtue of Khatyan.
So it is one thing if it was originally agricultural land, subsequently got converted into basti land and they still remain in occupation. That aspect, my lord, it's not very clear unless and I look into the exhibits also, my lord. I have applied for copies, my lord. It is fixed for hearing, otherwise it's a matter ready for hearing. It's fixed for hearing, my lord, shortly.
In this 2009 to 2016 matter, every time is a hearing time.
I understand, my lord, but then the circumstances are so that I could not be let out prepare with the papers, my lord. Sometime in second week of June, my lord.
Senior counsel B.K. Sharma has gone to Delhi for his treatment.
Nothing. Nothing. You can just give a short adjournment, nothing more if he is gone for his treatment.
My lord.
Anything serious about him? No.
So it would be required 1 month's time. After 4 weeks, may be fixed.
And sometime after vacation, my lord. I'll make sure that, my lord, no further adjournment from our side. We'll definitely do it, my lord.
It is represented. He particularly comes to the appellant and Miss
P. Sharma.
P. Sharma and P. Sharma and respondent numbers 1 and 2 both paid for a job. The run cost for the respondent numbers 1 and 2 is predicted. So P. K. Sharma who's leading now in the matter for the respondent numbers 1 and 2. He's gone to Delhi for his medical treatment and paid for 1 month's time. Considering the pay for German on medical grounds, the learned counsel holding the brief for the respondents. The case is ready for hearing. This is the matter for hearing on 14/7/2026. Is made clear that no adjournment, no prayer for adjournment shall be considered on the next date. Is the it is pending for disposal since 2015. We have given a fixed date of
My
hearing
lord,
on
14 July.
14/7, no adjournment. Even on ground of payment. We do not have ordinarily granted for the Sharma is a senior person. We have to consider his case for the medical grounds. Anything serious about it? No.
No.
Yes. Item
Deeply,
7.
deeply obliged.
My lord, I will take your lordships to order dated 13/5.
13/5. Yes.
Second paragraph.
Process service report.
Yes. In terms of that. I'll take your lordship to page 2, my lord. Order dated 6/6/2022.
Page number
Page 2
of this.
of this photo step. Order dated 6/6/2022, your lordship will find the plaintiff is represented. Today, the learned counsel for the defendant number 2 has appeared without wakalatnama and white petition being numbered so and so, showing cause praise to fix another date for filing WS and wakalatnama. Your lordship kindly mark WS and wakalatnama. Now, the next date is 14/7. Now, on 14/7, the parties are duly represented, seen petition number so and so, filed by defendant number 2, paying for fixing another date for fixing written statement. Now, fix so and so for WS and wakalatnama. Then again in the next page, order dated 25/7, the parties are duly represented, same petition number so and so, filed with the learned counsel for the defendant, praying for another date for filing written statement, showing the cause of the defendant is lying sick. Then fixed on so and so, written statement on wakalatnama. Now, our stand is, my lord, we never engaged any advocate
we have categorically stated that. And your lordship has seen on all the dates for filing Vakalatnama. I can understand, my lord, once the advocate will appear without any Vakalatnama, but not on all those dates. Then your lordship turn to, order dated 17/8/2022. Plaintiff is duly represented, the defendant is absent without steps, fixing so and so for WS and Vakalatnama. Then at page 4, 16(9), the plaintiff is duly represented, the defendant is absent without any step, fixed so and so, so and so. Then 10/11/22, the plaintiff is duly represented, the defendant is absent without any step. On perusal of the case record is revealed, the defendant number 2 first appeared on so and so without Vakalatnama and sought adjournment, which was allowed. The case record also reveals that the defendant number 2 remained absent in last 2 consecutive days without steps and is absent today. Considering his absence, the suit shall proceed ex parte against the defendant number 2, fixed so and so for ex parte evidence. Now it proceeded ex parte, then my lord, your lordship can come to page 6. Is the postal receipt, my lord. Postal receipt, your lordship will find, it was posted from Seniram Bazar sub office on 18/5/2022 to, this is from Tinshukia, to Pankaj Sanitation, Narangi sub office. Then they relied on the tracking report, which your lordship will find at page 7.
Item delivery confirmed.
I'll take your lordship from down, 22/5/2022. Now, item dispatched. Then your lordship from down up to 12 number, if your lordship look at.
Redirected.
Narangi sub office, item redirected to Udayan Bihar, insufficient address. Then your lordship come to on the top, 26/5/2022, Udayan Bihar, item delivery confirmed. If it is insufficient address, well, I do not understand how it can be confirmed. Now, assuming that it is confirmed, everything is okay. Even in that case, my lord, the postal peon ought to have been produced by giving evidence and all.
So we accept the postal delivery track reports.
No, my lord, the track report was a photostat copy. Now, if this is to be accepted as toto, my lord, your lordship kindly see the background. On 3
We
occasions,
could have understood if you have filed an FIR against the lawyer. Yes. You disclose his name as to who has appeared, the name and name of the lawyer.
no, those
And-
things of course we did not.
And if you don't file an FIR against the lawyer for appearing without Vakalatnama, we can't consider your case.
Now, this,
There
if
is no
it is,
complaint against the bar council, your right to.
no,
defend has been
those are
taken
the
away.
things, my lord, I am not disputing. What your lordship fallen from your lordship is very correct, my lord. But then your lordship kindly see, if it is an insufficient address, my lord, how it could be confirmed under that circumstances, my lord?
No, I don't know, you see. Yesterday, I'll show you, I have a postal receipt. Yesterday, a letter was served on me. So and so, Gauhati High Court, Gauhati. And it came. And if you read that envelope, there is no address at all. Gauhati High Court, Gauhati, and it has come. Address is insufficient, but does not debar our postal authorities to do the hard work and find out and serve it.
Now, here, why I am saying, my lord, if your lordship look at destination pin code, your lordship kindly see. Pin code is 781171. Now, if we look at that, the destination station is Pathar Query. And your lordship kindly see the postal, the postal receipt. It is Patharguri. The postal receipt, if your lordship see it in the page 6.
Page 6.
This page 6, if your lordship see that, to Pankaj sanitation,
Patharguri.
it is Patharguri. But-
Incidentally, come to your page 2 of your application.
My lord, yes, my lord, what happened, your lordship, I wanted to say that also. They have given a incorrect address in the plate, and my lord, what we have done, in our petition also we have followed, which is
Okay, and paste.
the copy paste is, your lordship can understand. And exactly, my lord, as your lordship has said, I asked him how we also committed the same mistake. Because the age of, my lord, the copy paste.
They would have understood. They can still adjourn it for a week. You lodge an FIR against the lawyer, disclose his name. If somebody has appeared, it will be a.
My lord, in fact, I suggested them, but they are really scared of doing all these things. They said, we just wanted to have a chance to contest the case. Therefore, we don't like to go into all that because we're not litigant, we don't want to place ourselves in that position. So only, my lord, the prayer is let us have a chance. And if your lordship give me a chance that if I can take your lordship certain decision of the appeals court, my
You
lord.
can adjourn it for a week, considering your prayer. Unless you file an FIR, you are not, or proceeding against the lawyer, you are not interfering. Very clear. Lawyers were appearing and then.
My lord, can your lordship give us a some time so that we can talk to our client?
Take it next week.
Yes,
Not for a week. Okay. There's the part on the computer sticker reference to the particular to the if it responded to present. If it responded to present. Save the pattern for the petition to the different date. This one. Suggest a date. Just see the date.
Good evening, sir.
Then 29 or 28.
So can it be on 29th?
Look, 29, 526.
All right.
This doctor. We'll take it back on the next day.
All right.
Back to video conferencing. Video nobody has appeared. The video nobody has appeared. Anybody has appeared for video conferencing? Exactly. Second part. Second part. Item 2. You were referring, I think you were.
Yes,
making a comment.
my learned senior.
You were at page 24 and page 30. You had referred to page 24 and then page 30.
Yes. Paragraph 10. I say that the respondents are still putting the lawful, unlawful threatening and trying to grab the aforesaid land to me. Grab the land which I am afraid of entering into this land for cultivation, which is now vacant, and as such, the aforesaid illegal
You
land.
are reading where, Mr. Sharma? You were reading which page?
Page 30.
Yes.
Paragraph number 10.
Yes.
Therefore, the land as on today, it is in my possession, madam.
But then you see, Mr. Datta has made a very strong point that you have, what is called the land grabbing did not take place. You are the complainant.
And
The land grabbing did not take place. And you have produced PW 2 and 3. 3 says that he has not seen Ahmad Ali illegally occupying the land. He does not know who is in possession.
but the land, it is a cultivable land. Seasonal crops are going on.
We have seen oral evidence that he started to take what you call to plow the land.
AW 2 and 3, they are the scribe and the witness.
If your allegation is that he tried to plow the land,
Land grab or tried to grab.
by using tractor. If a tractor is plowed, many nearby people will look at it. There's no witness other than this court clerk. Mori comes and says that he has heard. If you are in possession, I'm just trying to, I'm trying to visualize the situation. I may be wrong, because I don't have that experience in agriculture. July is the month when the winter crops can be grown. It is paddy. How much time it will take to grow paddy? There will be some sowing period. How much time is that to sow seeds? How much time it takes for the paddy to grow and be transplanted to the land?
Generally harvesting January.
No, winter crops will come in July, 6 months before. July is the prime time to sow the paddy for winter.
Yes.
How much time it takes for the seeds to grow? Any idea?
My learned friend says around 120 days, 100 days. around
120 days, 3
100
months.
and 3 months. yeah.
Okay, that is the right time. It's 3 months time for the paddy to grow.
Yes.
Therefore, if he has plowed the land in July 2015, you would have earned paddy if you are in possession. You benefit out of this activity. You have plowed your land.
Yes.
And how much land is that? 2 katha 5 3 biga 2 katha 5 lacha.
Yes.
To grow paddy in that field, how much time would it take for the tractor to be operated?
But this is a part of it is a big plot
I
of.
understand. I'm just trying to, I told you, I have no experience in agriculture. I'm trying to visualize. If somebody goes and plows 3 bighas of land, I'm just asking myself how much time it will take for a tractor to work on a 3 bigha field.
So this will take
1 day.
1 day.
No. In 1 day, that will not happen. 1 day, it will not happen.
Actor.
Then you would have had sufficient time to inform the police when the factor was actually, even if we assume that you are right, it will take 1 day. Then perhaps you would have enough time to go and inform the police, have that tractor seized and all that. That was never done. There was no fight. Any relation? You have similar names. Any relation between you two?
Brothers.
Brothers.
This is ancestral land.
Hmm?
This is ancestral land, actually.
This
He
is
says-
ancestral land, this land was gifted to me
That's what it says.
and I am in possession.
Who gifted that land to you?
It was given
Well,
to,
my father,
had gifted it
already-
to another son, madam. And he gifted it to my friend's client. It was my lord Afaduddin Sheikh, Altazuddin Sheikh, my lord. He, my lord, gifted it to his second son, Azizur Rahman. And my lord, he gifted it to the complainant. The two gifted. Altazuddin Sheikh is the father of both, my lord. And my lord, he gifted it to his second son, Azizur Rahman, who is not alive.
page 17 of Lordship,
Okay.
1/7. The complainant is the absolute owner and possessor of property. Para 2.
Mr. Sharma, you will be more adapted to the internet than senior Mr. Sharma. Correct? Put out your mobile and just make a Google search. What is a sali paddy, SALI, sali paddy? Sali, according to my understanding, is a winter crop. SALI. Just go outside. It's not working. Okay, then leave it. Yes, I'll send you this. Okay. Winter crop. Winter crop. No, I'll send you this if the net is not working. I repeat it for you. That is a winter crop, and July is the prime time to grow. Yes. In your petition at page 17, which Mr. Sharma made me read, Senior Mr. Sharma, you have the gift deed of 4/1/2007, and then you say that you have been possessing this headland by way of cultivation and raising sali crops. The complaint was filed on 21/7. In 21/7, you will not have sali crops because you will be sowing seeds at that time. Crop will not be ready. He says 120 days for the crop to be ready, then transplant. The premise on which this paragraph 3 is structured may not be correct.
He further says in paragraph 3, that he has been till date peacefully, openly to the knowledge of all concerned, possessing the land.
That's okay. The registered sale deed, we don't make any comment.
No, on the possession, Since then, the complainant, say paragraph 3, last but about from middle 3 lines, 4 lines from the top, paragraph 3. Since then, the complainant, after accepting the gift, has been possessing the said land by way of cultivation and raising sali crops till date peacefully, openly to the knowledge of all concerned.
Sharma, find more force in the submission of Mr. Datta this time. This position was not, the position was, does not appear to be free and open. Come to page 46. 46. Yeah. And see, this is how a deed is executed. Para 10. CW3 has deposed that he is the scribe of Exhibit 2. On so the petitioner along with Azizuman had come to the office of sub-registrar and had requested him to write a gift deed. And accordingly, he had written gift Exhibit 2 and duly executed by so and so. That means deed was drafted in sub-registrar's office. And therefore, you will not be opening because if you do that, normally it is very difficult to accept that it was very close to the affair. Only 2 or 3 people know that the execution is being made.
Why are these structures, they are very expert person in writing the deed. They can write in the, we have seen in our Kasaragod so many old.
We have seen it, that is why you see these issues. Because father does not want the second son to know it, and therefore goes to the sub-registrar office and gets it done there.
So suppose you go through their written statement.
And then to put out the brother to make any claim, this case has been filed. So that he is entangled and elsewhere and then can't disturb your position. So Mr. Sharma, and what's the submission of Mr. Dutta?
Mother, the, so far the possession is concerned, that is why, so far title is concerned, that is, I am protected.
Title we will not touch. Title we are not touching. It is only the civil liability and the criminal liability. You can examine. Which page is the interim order? Page 41.
Yes.
Well, I have,
Here,
I have recently gone through a judgment of the Supreme Court. Here, the Supreme Court has discussed the power under Article 227. Whether the High Court can appreciate the evidence. Here, para 35, which you can see.
oh, this is the Dundee infrastructure. Para 35.
Para 35. Para 35 onwards.
Yes. deal with it.
Under this act, one of the problems we are facing is that the appellate authority is not there. So that's why the writ or initially it was filed as a writ petition, that was converted to 27 petition. That aspect is also there.
And with that, I was saying, it can be process of dispute. Also heard. Mr. K. Sharma, and its senior counsel, assisted by Mr. M.P. Sharma, G. Bharadwaj, for the respondent numbers 1 to 4. 4 Roman also had the government and additional senior government advocate appearing for the respondent number 2 and 3, and you are there. The J. Andy Clement, and also for the revenue department, appearing for the respondent number 1. So you take petitioners 1. 150 is the appendix 2 and 3 per one. Then 4A.
Whatever, yeah.
The petitioners are the accused in the proceedings of LG within the land grabbing case number 45 of 2015. It was filed before the special tribunal Gualpara, which is a special tribunal with the district and with the district and session judge as the presiding officer. The case of the respondent number 4 is who's the substituted respondent number 4A with the substituted respondent number 4. On death of the original respondent number 4, namely Muhammad M.D. Afaz A.F.Z. Afaz Ali, is that the original owner of the land was Muhammad Altazuddin, A-L-T-A-Z-U-D-D-I-N, Sheikh, S-K. The father of the respondent, original respondent number 4, by executing a registered gift deed bearing registration number 3585 of the 3349 dated 9/8/1982. thereafter on 4/1/2027, Azizur Rahman is that I read to Azizur Rahman, the father of the person respondent number 4, gifted the said land to him by gift deed, registered gift deed number 1/8/16, and the said respondent or said original respondent claim to be in peaceful and within possession of the said land. It is projected in the complaint filed on 21/7/2016 before the Gauhati Special Tribunal that sometime in the middle of May 2015, the petitioner illegally, by using force, tried to grab the land, but due to timely intervention of the case, the intervention arising out of case filed by the original respondent number 4 under section 107 of the 144 of the 145 CRPC. The case number 99 of the 15, the petitioners could not enter the suit land. Thereafter on 27/2015, the petitioner allegedly tried to dispose the original respondent from the disputed land on the strength of their muscle power to threatening him of consequences, had also allegedly plowed the suit land by tractor and did not stop their illegal activities. Accordingly, the respondent number, original respondent number 4 had projected that he has suffered loss. Accordingly, on the ground that cause of action arose on 27/16, proceeding was initiated. The period to take cognizance of the offence under subsection 2 of section 8 of the land, Assam land grabbing within the Prohibitions by Act of 2010, and to declare the right title interest of the original respondent number 4 in respect to the suit land and to disperse this to the ownership and distribution and to impose punishment and for reasonable compensation, section 4, section 3, reference section 5 of the 2010 Act. But Mr. Sharma, the player is interesting. Page 20. Player is interesting. Fifth line, and restore peaceful ownership and possession of the complainant forfeit of the suit land by protecting the accused of the land grabbers. And for the said complaint, the description of the suit land is measuring the schedule of suit land is land measuring 3 biga, 2 katha, 5 lecha, under Revenue Village, HATI, Gaon network, under Matia Circle of Gauhati district, covered by tract number 154 within bracket hold, public 70 within bracket new, Khatian number 188, Pata number 368 within bracket new, with definite boundaries as mentioned in the schedule of the complaint. Next, the petitioner contested the said proceeding by claiming that the gift deed was forged and the same was a false gift deed made by way of impersonation. And denied that the original respondent before had any right, title or interest over the said gifted land. And it is also alleged that the land was mutated in conspiracy with the concerned land holder. And when he came to know about it, application was filed against mutation, but no proceeding commenced before the Matias Circle office. And also claimed that late Authorised, ALTAJ, Authorised had executed a will on 28/2/2003 in favor of the petitioner in presence of witnesses, which was registered in the office of the qualifier. He came to be in possession of the said land of sense of the will. Denied the allegation of land grabbing as false. Mr. Sharma, please confirm this page 31. Page 31. These are Sophie's Tarike Vivatio, John Robert Manu, Boy, Boy Ahi, More, Ketafal, Parat Ave, Rabuki, Dia, Pata, Hatuna. This is PW1. Is denied.
Yes, denied, right? That's correct.
Himself as PW1 and he had examined one Anwar Hussain as from a petition writer by profession as PW2. And also examine one Sahab Ali, a deed writer, a licensed deed writer as PW3. On the basis of the, you did not give any evidence.
No, my lord, no.
No evidence was met by the petitioner's side. Based on the discussion on the evidence on the court, done it special tribunal by around 26 for 2022. The discussion on 5. It's same. So it was same. Declared the petitioner to be a land grabber as defined under section 2 within bracket T. 2010 Act was liable to be prosecuted for commission of offense under section 4 of the Act. And directed that the respondent of 4 shall be put in possession of the scheduled land after expiry of the appeal period, and compensation was compensation for legal position was quantified at rupees 1 lakh to be recovered as land revenue from the protection. It is said that this is examined from a respondent of 4 had exhibited registered give date number exhibit 1, registered give date exhibit 2, copy of Javavanti exhibit 3, and land holding certificate exhibit 4. Where is this land holding certificate? This copy available? Please take out. For record for some.
Exhibits are not there, I mean. Exhibits are not the part of the like, my petition.
Sharma, this exhibit 4 has destroyed your case. Here, have you seen that exhibit 4? No. It has destroyed your case totally. The land grabbing happened when?
They said 27, 2016, 20th of July.
7, 2016. This is the land grabbing report. Says that no one is in possession. The tribunal issues a ask for the report, and this is the report which has come. look at the prior page, that is exhibit 4. No, prior page. So before that, there is a plastic coated. Yes. Till 15, you were in possession. And when the next report comes in 16, nobody is in possession.
No, they, actually it is a delay.
We don't know, but you see, this is a report. How can we now disbelieve that report? This report was never questioned. That means the tribunal knew on that day that nobody in possession. So therefore, 1 lakh rupees cost, how can it be imposed? You'll have to have a finding that the land grabbing was from this period to this period, and therefore compensation. That arithmetic was not done. The date on which possession was taken, the evidence of PW3, I do not know. We continue at 2.
Right.
The done after the petitioner by looking at the cross-examination of PW1 and PW3. As well as the statement made in paragraph 5 of the complaint petition has submitted that as per the statement made in paragraph 5 of the complaint, the allegation is that the petitioner was trying to dispossess the original respondent number 4 and the PW1 it is cross-examination. Made a statement that it is not a fact that on 27/2016, the respondent along with his men came and threatened to dispossess me. And the PW3 in his cross-examination stated that he had not seen the petitioner illegally occupying the disputed land. He did not know who was in possession there. He had stated that he had not read the evidence of imprisonment, so he had not received it. Accordingly, it is permitted that in addition that any attempt was made for disposition was not owned by the public. The one at senior counsel for the executive respondent has made his submissions in support of the interim order. It is submitted that there are limitations on power of the court. In the Article 227 of the Constitution of India to interfere with the
order passed by the special tribunal. And this is stated and by referring to paragraph 30 of the case of Nandi Infrastructure Corridor Enterprises Limited. And another versus P. Gurappa, GURAPPA, report 92 NAIDU, civil appeal number 158 of 2015. Decided on 34/2026. Twenty 2026, SCC online, SC 755. Right. It says that the High Court, when exercising supervisory jurisdiction, does not the report of first appeal just to re-appreciate on reweigh the evidence or facts upon which the determination and the challenge is based. Accordingly, it's submitted that the unwarranted assumption of jurisdiction was not to be made in exercise of jurisdiction under Article 227 of the Constitution. It's submitted that as the the Honorable Four has been able to prove that there was an attempt for land grabbing of such an act of attempt to land grabbing. It's an offense I will take a clue of the Assam grant levy within packet prohibition, packet to act from a regarding the says rejection of Article 227, Article 108. Of the order implementing this application. This look at that at paragraph 23 thereof. The learned tribunal has referred to the report dated 8/2017 of the special officer from Alia, for which the learned tribunal has taken judicial notice. So, as to the said report, the revenue staff on spot verification found that the land was lying vacant since the year 2015 and nobody was in possession. The The report also reveals that in the cross-examination from the PW1, we also admitted regarding the same that as per the report, the land is not in position of any of them. Both the words, any of them indicate both the, would include both the petitioner and the respondent and the further respondent. This part. Therefore, the allegation of land grabbing first raised was the first allegation of land grabbing in the complaint petition is a specific date of 27/2016. Is the serious case of the respondent in the complaint petition that an attempt was made for land grabbing in middle part of May 2015, but due to timely intervention by the case filed by the respondent number 4 under section 107 of the 144 of the 145 filed before the Court of Executive Magistrate from Agualpara in case number 99 of the 13. The petitioner could neither enter into plan nor succeed in threatening. And the said case was ended when the appellant continued to possess the plan in 27/2015. So, reading at paragraph 5 of the complaint petition. The decision, the finding of the learned special tribunal that the petitioner was in illegal possession of this land since last 7 years. From the date of the order,
the first one, 26/4/2022, is not found by the details or the evidence on record. Because 7 years from 26/4/2022 would be in the year 2017. It is nobody's case that after the receipt of the report by the executive magistrate Gauhati dated 10/8/2015. No, sorry, not 10/8/15, it should be detailed report sent before the special tribunal by the circle officer, Natia Revenue Center on 2/8/2017. The land was grabbed by the petitioner and he was in illegal possession of the said land. It may be mentioned that as per the province records, for the evidence on affidavit of PW1, PW2, and PW2 were filed on 28 September 2018. And filed before the Special Tribunal on 28/9/2018. And where PW1 was cross-examined on 8/11/2018. PW was cross-examined on May 2019. The evidence on affidavit of PWC was sworn on 22/7/2019. And on the same day before the learned tribunal. He was cross-examined on 4/10/2015. PW4 was filed on 3/9/2019, and he was also cross-examined. No, not quoted. The This is previous process, 26 to 2020, PW4. Cross examine. Appear for his present. He did not appear for present. PW4.
Milord, PW? Four. Four, Milord, no, Milord. I have not, next also, Milord, I think, Milord, there is three. Could you turn up the concentration, what will be?
The student of course, the order dated 14/12/2021. In 2022. Right. It is for examination of Peter four. So how is the evidence was closed for article where that for further to recording the evidence of instead PW1, PW2, and PW3 that the that pursuant to that after the after 2/8/2017, the date of report by the Circle Officer, Matia Revenue Circle on disputed land, the respondent was, so the respondent before was dispossessed from their land. The finding of the respondent before being dispossessed in the direction for the respondent before to be put into possession of this land. Yours, the or evidence on record. Therefore, this is the case where the learned tribunal is going to have considered details extraneous to the record. Arrived at the conclusion so any evidence on record. The result of the constitution of the compensation of the contract. Also without any basis. It is clearly stated that the responsible court did not amend the complaint to allege that from 2017 to 26/4/2022, from the date of judgment, the responsible court was dispossessed from the land by the act of land grabbing by the petitioner. Next question. Coming to the issue of the limitations on the power of the court, the article in the seven of the Constitution here. It may be mentioned that the Assam land grabbing within bracket prohibition, bracket act of 2010. It's an act which received the assent of the President of India on 28/10/2011. And but 1811 now, it was published in the Assam Act as it accordingly. Number 410 dated 18/11/2011. So the said special act to deal with land grabbing cases in the state of Assam provides for constitution of special tribunal under Section 7 of the said act. So the said act is a self-contained act containing the powers of the special tribunal and the procedure to be followed for trial of the case. With special provisions for burden of proof. Full stop. Section 13 of the said 2010 Act provides for fee by providing that any person aggrieved by the judgment and order for not being an interrogatory order from a special tribunal may prefer and fee before the special court on any question of law or of fact. Full stop. It is not within the knowledge of the court as to whether special court, their appeal has been notified. And therefore, on a query of the court, the done it counsel of both sides has submitted that no special court has been notified to hear appeal. But notified by the state of, by the government of Assam, providing for there is rejection to such court to hear appeal under Section 13 of the State Act. Next one. In the considered opinion of the court, the act, special act provides for it is a self-contained court, therefore, and provides for an adequate forum. Just because the state, in its wisdom, has not notified a special court to hear appeal. This court so the party agreed by the decision of the special tribunal cannot be that remediless. And therefore, this court, there is no option but to here arrange to be orders passed, final orders passed by the special tribunal in exercise of petition, maybe under Article 226 and or 27. Therefore, when there's no appellate forum, the court cannot be obvious procedures to be proceedings and nature of evidence which has been which was available before the learned tribunal. For in the present case in hand, the learned tribunal has found to have arrived at the conclusion that the petitioner was a land grabber and his position was 7 years from the date of the for a date. This is for 2022. This is neither takings nor evidence to that effect. Another formality. PW1 denies that the land grabbing took place, and the PW3 denies any knowledge of it. Therefore, the decision of the private tribunal want to be covered and not bound by the. It is an evidence of how. Therefore, the decision of Nandi infrastructure corridor municipality cited by the management of the fund by four. How to be count of trading. Since the petitioner, sorry, the son of four. In paragraph, for the set purpose of paragraph 36.1. Right. ABC, 56.1. Six point two. Put it here. Okay. Therefore, put it classic. Observations of the Supreme Court of India in the case of county infrastructure, corridor and as it is. Happening from the case of record that the learned tribunal needed to appreciate the statement made by TW1 and TW3 in the process only. Which I referred above. It is not a mere legal flaw in the Indian opinion, but the decision of the cabinet to become perverse for viewers of the without taking into account the reason from the farm. In the absence of pleading, the special cabinet arrived with the finding that the respondent, original respondent was excluded from the bank. So, it could be a case of gross abuse or doing it. No amount of evidence could have been considered your pleadings. And the pleading from a record about. Let me say that the respondent who has continued to possess the bank in 27/2016 and on 27/2016 and open for reporting. Respondent 4. And therefore feeling that One from 27/2015. It is not in possession of this land. It is regarding cause of action. Because it says it is true that the concept of the in that's one of the four. Whereas on the contrary, the report which was not from the inspector officer. It was received by the 8/2017. Clearly discloses that the land, the disputed land was cultivated by alia, ADHI. This bracket. Person who cultivates land by takes the share of the produce. Namely, so that's with you. Elias, memo, I know, sale after the year 2015. And presently, the disputed land was lying vacant since 2015 and nobody is focusing on the land. We said before, so I indicated about this. Offered 2017 and no attempt for creating. To dispute the set, to conduct the set. Before. A report which is called for by the court. Partakes a character of the evidence. Be evident from the provisions of Order 26 to 10 to the second Q of the city. And accordingly, the said report was duly considered by the ruling tribunal. Okay, so instead in instance to hold that the petitioner was disposed on this, they had fallen, who was disposed 7 years prior to file. 26. Court of Appeal. The court is trying to put that. Until after 2026, court is going to further. Going to be getting the notice of the part. So, petition to secretary. He said, in order to. Rightly pointed out. This book is not exciting as particular candidates in the country to be. Responding number, certificate responding number 2 that this book is not in question of any appeal. The court is inclined to revamp the back and matter back to the head on the tribunal. So hear the matter again. The basis of evidence property and freedom of the court. And to pass the fact. What is the law? It will be the activity relating to
Worship, in this matter, my senior ambassador is on legs. And continue.
Your Lordship, from the side of the petitioner, almost they have actually finished their argument. And if something remains also, Your Lordship, I may be permitted to place my side of argument, Your Lordship. I will not take much time, Your Lordship. Within 15 minutes, I'll take notes. So let me complete my side, and if it comes, Your Lordship, will argue the remaining part. Thank you, ma'am. Very pleased, Your Lordship. Lordship, this is a matter, Your Lordship knows that this is under Order 7, Rule 11. And this they have not mentioned, Your Lordship, whether it is under clause A or clause D or any other clauses, Your Lordship, of Order 7, Rule 11. But anyway, Your Lordship, according to them, that the plaint is liable to be rejected, Your Lordship, and why it is to be rejected? There is no such manifest ground, Your Lordship, they have taken into petition. Now, Your Lordship knows, for rejecting, Your Lordship, a plaint, Your Lordship, the statements made in the written statement or statements or other averments made in the application under Order 7, Rule 11, that cannot be considered. Only the plaint as a whole, Your Lordship, it is to be considered, and whether from those statements or the pleadings as appear from the plaint, Your Lordship, there is any ground for rejection of the plaint either under Order 7, Rule 11, A or D, Your Lordship. So for C and D is concerned, Your Lordship, it is not applicable in our case. Their petition, so far under Order 7, Rule 11 is concerned, it is very cryptic, Your Lordship. There is no particular provisions they have shown, Your Lordship, and no particular statements or averments they have actually quoted from the plaint, that because of this, the plaint is liable to be rejected, Your Lordship, it is to be returned. Now, Your Lordship will find what is Order 7, Rule 11, A and D, Your Lordship. I just placing it as a cursory look, Your Lordship. Rejection of plaint, that is Order 7, Rule 11. The plaint shall be rejected on in the following cases where it does not disclose a cause of action. B, where the relief claimed is undervalued and the plaintiff is being required by the court to correct the valuation within the time to be fixed by the court, fails to do so, where the relief claim is properly valued, but the plaint is not retained, so this B and C is not applicable. D, where the suit appears from the statement in the plaint to be barred by any law. So this is important, Your Lordship, where the suit appears from the statement in the plaint to be barred by any law. My learned friend has argued, Your Lordship, at length, could not show that there is no cause of action, that the plaint is barred because of the statements, such and such statements made in the plaint, Your Lordship. Now, Your Lordship, just I am placing the facts in a nutshell like this, Your Lordship. The predecessor of the present petitioners, Your Lordship, the predecessor of the present petitioners, Your Lordship, he was the owner of land measuring 4 kota, 13.5 lesser, Your Lordship, covered by particular dag and patta. He was also owner of the adjacent plot of land measuring 1 kota, 5 lesser, Your Lordship, covered by some dags and pattas, Your Lordship. So in total, Your Lordship, he was the owner of 1 biga, 18.5 lesser of land. First, Your Lordship, on 28/2/2018, on negotiations and discussions, Your Lordship, he proposed to us, Your Lordship, that his land should be developed by the respondent here, Your Lordship, that is the plaintiff. So after negotiations, Your Lordship, an agreement was entered into on 28/2/2018, being numbered 2458 of 2018. In respect of the first plot of land, that is 4 kota, 13.5 lesser. Thereafter, Your Lordship, after a month, he again approached the builder, that is the present respondent plaintiff, Your Lordship, that he wants to develop the other plot which is adjacent and awarded to the earlier plot of land, that is 4 kota, 13.5 lesser, Your Lordship. In respect of that 4 kota, 1 kota, 5 lesser, he wants that it should also be developed along with the earlier plot of land. Very good, Your Lordship. To that effect, Your Lordship, an agreement was entered into on 27/3/2018, exactly after 1 month of the earlier agreement for development, Your Lordship. And that agreement is being numbered as 3861 of 18, Your Lordship, that is 27/3/2018. So in total, Your Lordship, both the agreement, Your Lordship, covers a plot of land 1 biga, 18.5 lesser. So in respect of the first agreement, Your Lordship, the present respondent plaintiff had to pay a consideration of rupees, Your Lordship, that is 30 lakhs, out of which he paid on different dates, Your Lordship, 17 lakhs. And in respect of the second agreement, Your
First
Lordship,
land is how much, you said?
Lordship,
How much is the first land?
land,
Area of land?
area of land in both the cases, Your Lordship, because this second case and this case, Your Lordship, it is same, Your Lordship. Total land is 1 biga, 18.5 lesser. First agreement covers 4 kota, 13.5 lesser. Second agreement 1 kota, 5 lesser. Makes 1 biga, 18.5 lesser. Yes. So, out of the consideration to be paid, Your Lordship, as advance, Your Lordship, 30 lakhs, Your Lordship, in respect of the first agreement, that is 28/2/18, and second agreement, it is 10 lakhs, your lordship, that is agreement dated 27/3/2018. And out of that, your lordship, he realized a sum of rupees total for both the agreements, your lordship, 22 lakhs. 22 lakhs. And as per your lordship, clause 7 of Article 3, your lordship, is to deliver the possession of the land, your lordship, within 3 months. That is, your lordship will come to the page, page 51, your lordship, of the agreement, your lordship, that is Article 3, clause 7, page 51, your lordship. Got it, your lordship. Yes, yes. The landowner shall hand over all relevant documents, deeds, receipts, and certificates relating to the title of the suit, sale and property to the developer builder at the time of delivery of possession of the scheduled A land, that is within 3 months from the date of execution of this deed. Similar is the provision in the other agreement also, your lordship. Same Article 3, clause 7, your lordship, that possession must be delivered with along with the title documents, other documents, certificates, whatever was there, your lordship, related to that land, your lordship, within 3 months. So he also executed a power of attorney, your lordship, in favor of the builder, your lordship. That general power of attorney was executed when it was when the first agreement was executed, your lordship, that is 28/2/2018, being numbered, your lordship, crossed under the clause 2 of general power of attorney, your lordship, that is at page 30, your lordship will find. As per the general power of attorney, the builder has been authorized, your lordship. He has been authorized, your lordship, that he would do everything by virtue of that agreement, obtaining permission, developing the land, taking other permission NOCs from different authorities. All things, your lordship, related to that land as well as for the construction of the building, your lordship, whatever is necessary by virtue of that general power of attorney, your lordship, that is 28/2/18, that was also given as per the terms of the agreement under the boat agreement, your lordship. So when you have realized, your lordship, as per the agreement 22 lakhs, your lordship, that goes to show, your lordship, that the builder, the constructor, promoter, your lordship, he has acquired or he has acquired, your lordship, some sort of right over the land. He is vested with some right, your lordship, with respect to the land, your lordship, to develop it. Now, your lordship, when time passed like this, your lordship, it was insisted upon him that he should deliver the possession of the land, your lordship, to him as your lordship stipulated or negotiated by virtue of clause, your lordship, 7 of Article 3, as I have taken, your lordship, just now. Now, he on this and that plea, your lordship, deferred the matter. He was not giving the possession to the builder, and that way passed, your lordship, a good sufficient time, your lordship. Thereafter, your lordship, when it was insisted, your lordship, he demanded more money, your lordship. When he demanded more money, your lordship, that is beyond 22 lakhs, your lordship. So the builder, your lordship, though it was not on his part as a responsibility or obligation, your lordship, to make any payment, because the other payments are to be made, your lordship. Balance payment is to be made, your lordship, only after obtaining the NOC. Anyway, your lordship, without showing any reason, without informing the builder, your lordship, he withdrew the general power of attorney, your lordship, which is irrevocable in nature, your lordship. That irrevocable power of attorney, your lordship will find
We have seen that page 95.
lordship.
95 and 97. See that.
So 2018, the general power of attorney, your lordship, will cancel it, your lordship. And it was informed to me, your lordship, that that is petitioner of the present petitioner, he is not interested to get it done, your lordship, to execute the construction work to the present builder, your lordship. And he withdrew the power of attorney, and also your lordship did not deliver the possession of the land. He also pretend that the agreements which were entered into in between him and the builder, those will also be cancelled, your lordship. That way he has treated, your lordship. So that being the position, your lordship, when I have accrued some vested right or interest over the land as described, your lordship, in the schedule, that is 1 bigger 18.5 lesser, your lordship, I did not have an alternative remedy, so I served notices that you give me the fresh general power of attorney and you don't cancel the agreement for development. Because I have accrued some right over it, it is vested with me, and that is why you can't, under the law of the contract, you can't withdraw, cancel the general power of attorney as well as you cancel the agreement for development. So after that, your lordship, he did not pay any heed, your lordship, he remained that way, your lordship, and he kept silence. So being failed, your lordship, in all aspects, your lordship. So after having served number of representation letters, public notices, your lordship, upon the petitioner of the present petitioner, as he did not get any positive response, your lordship, so he was compelled to file the present 2 suits, your lordship, for implementation of the agreement, your lordship, that is agreement number 245818.
You have raised the fee of arbitration clause. You gave a.
My lordship, that has been waived by them also, your lordship, and we have also, your lordship, waived by filing the suit, and they have accepted the suit, your lordship. They have not raised any objection to that. That there is a clause for arbitration, and so it go to the arbitrator. They have not raised any objection to that. Anyway, your lordship, when they have not raised any objection and it accepted, your lordship, so the matter proceeded on, and they filed written statement, your lordship. So from the side of the plaintiff, evidence was also adduced, your lordship, was partly cross-examined. Thereafter, your lordship, they filed the present petition on the order 7 ruling before the trial court. Trial court considered the matter, your lordship, and by showing reasons, your lordship, and it was rejected, your lordship. As against that, they have come to this honorable court, your lordship, that the order passed by the trial court is not as per law, and the plaint should be rejected in both the cases, your lordship. Now, your lordship will come to the prayer in the plaint, your lordship. What is the prayer? So for the payment of 22 lakhs is concerned, your lordship, it is admitted position. They have not denied it, your lordship. Now, your lordship will find at page 37. 37 of the petition, your lordship. What are the prayers?
You've seen that last time. Okay, baby. Read it last time. The prayer was read by Mr. Chaudhary last time.
Lordship,
The prayer was already read by Mr. Chaudhary last time.
anyway, your lordship, from the prayer portion, your lordship will find there is a good case for giving relief. There is, if court finds that actually we are not entitled to get, the builder is not entitled to get specific performance, alternative remedy we have made, your lordship, as per section 20 would you make it clause 2 of the specific relief act, your lordship? As per that provision, your lordship, alternative remedy is permissible, your lordship. The specific relief act only. Section 22, power to grant relief for possession, partition, refund of earnest money, etc. Notwithstanding anything to the contrary contained in the Code of Civil Procedure, any person suing for the specific performance of a contract for the transfer of immovable property may, in an appropriate case, ask for his possession or partition and separate possession of the property in addition to such performance. B, any other relief to which he may be entitled, including the refund of the earnest money or deposit paid or made by him in case his claim for specific performance of the contract is refused, your lordship. So A and B, your lordship, as per possession, I can file partition is not necessary, separate possession, it is under, but so far possession is concerned, as suit lies, and so far deposit concerned for its refund, your lordship, as a alternative remedy, that is also permissible. And your lordship, it is a suit for declaration of specific performance of contract, and in the alternative, your lordship, for realization of the sum of rupees 22 lakhs, your lordship, with 17 lakhs, your lordship, the other one is 5 lakhs, the other suit, because it will cover both the case, your lordship. Common judgment will cover this. Everything is same, your lordship, only two different agreements, your lordship, with two different and distinct plot of land, your lordship. So we have also prayed for a compensation, your lordship, that is liquidated compensation of 1 crore, your lordship, and the refund of the amount of rupees 17 lakhs with interest at the rate of 24%. Now, your lordship, the case is, your lordship, whether there is cause of action or not, for violation of my civil right by the predecessor of the present petitioner, that I am entitled as per the agreement to develop the land, your lordship, and it is to be delivered to me within 3 months from the date of execution of the thing, which he has not followed, neither he actually complied with. And under section 29 of the Contract Act, your lordship, it has binding effect. It has binding effect, your lordship. Both the parties are bound by the terms, conditions of the agreement. Now, as you failed and neglected to deliver possession, your lordship, as per clause 7 of Article 3, your lordship, so the suit has been filed, your lordship, that he may be directed by mandatory injunction to deliver the possession of both the plots of land, your lordship, that is by virtue of two agreements. So within 3 months, so that already elapsed, your lordship. Now, even then, your lordship, the court can pass, your lordship, mandatory injunction that you delivered possession to the builder so that he can develop the land. Now, so far reliefs are concerned, your lordship, whether it is granted or not, your lordship, that is up to the court. So far the realization of the amount or the refund of the amount is concerned, that is different. That means it contains a title suit, your lordship, for declaration of title, your lordship, as well as money decree, your lordship, so for the refund is concerned. So two suits are there, your lordship. One is money person, the other one is declaration purpose. So whether, your lordship, these facts as stated, pleaded in the plaint, your lordship, in details which has been pleaded, your lordship, whether it constitutes, your lordship, a violation on the part of the present petitioner, your lordship, regarding terms and conditions. If these are violated, then is violation of the civil right of the court.
Where there is a violation of civil rights, your lordship, there is the remedy. So remedy is, your lordship, whatever remedy is necessary, your lordship, which I have already stated, your lordship, that these remedies should be given to me, your lordship. And decree should be passed to that effect. Now, it is the duty of the person, duty of the defendant, your lordship, why I am not entitled to get those reliefs, your lordship. On the other day, your lordship, my learned friend for the petitioner argued. He has shown some provisions under section 14 of the old act as well as the new act, your lordship. Now he has confined his argument to the old act 14. But old act 14 does not help him, your lordship. Old act does not cover all these things, that if there is any violation, there is an agreement for development and violation, that no suit lies, your lordship. To that effect, there is nothing. To that effect, there is nothing, your lordship. Rather, your lordship, it encourages that if somebody is deprived of his right is violated otherwise, and that to civil rights, your lordship, after having paid such a good amount, your lordship, 22 lakhs in the year 2018 itself, your lordship, whether he gets relief or not before the trial court, it is up to the court which will decide. After recording evidence, everything, issues have been framed here, your lordship, everything has been done. Now, your lordship, it cannot be said that I am not entitled to get back the relief of this refund of the huge amount to the tune of rupees 22 lakhs, your lordship. If that be so, your lordship, let them show, your lordship, a single sentence, your lordship, in the plaint, that because of this sentence, this averment, I am not entitled to get specific performance of the contract, or I am not entitled to get the refund of the amount, your lordship. To that effect, my learned friend, though he argued, your lordship, lacked, your lordship, he could not show any averment statements in the plaint, your lordship. And as per the interpretation of the interpretation of Order 7, Rule 11, your lordship, Supreme Court has held that the entire plaint must be read in its entirety, without missing a link, without missing a word, without omitting a sentence. Lordship, to that effect, your lordship.
Submission of Mr. Chaudhary was to the effect that if it is section 14 under the before amendment, then the contract cannot be specifically enforced. Therefore, it is bad by law.
Now, your lordship, this section 14, your lordship, they confirmed your argument. Contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely, a contract for the non-performance of which compensation in money is an adequate relief. It does not come within it.
You can omit all everything
A
else.
contract, because
You can
it
directly
is,
come
it
to.
cannot be specified, because what will be the sufferings of the builder, your lordship, if for non-performance, your lordship, it cannot be specified. It is not a matter of injunction, your lordship. It is actually applicable only in case of permanent injunction or temporary injunction. A contract which runs into so minute or numerous, that is also not applicable here.
You can directly
A
come to-
contract which is
you
in
can-
its
you can directly come to-
determinable.
You can directly come to 14. The C, 14(3)(C),
14,
3C.
please see, your lordship, where the suit is for the enforcement of a contract, for the contract or construction of any building or execution of any other work on land. Your lordship, where the suit is, lordship, I am 3, notwithstanding anything contained in clause A or clause C or clause D of the subsection 1, the court may enforce specific performance in the following cases. The specific performance can be enforced, your lordship, in the following cases. See, your lordship, I am telling, where the suit is for enforcement of a contract for construction of any building or execution of any other work on land, your lord, this can be enforced.
It is the empowering provision, your lordship, it can be enforced. As per clause 3, subsection 3 of clause C, your lordship. So it can be, your lordship, enforced. Not that, your lordship, it cannot be enforced. So it is a positive clause, your lordship, that it gives the builder a right or the constructor a right, your lordship, that construction can be carried on, your lordship, and it can be enforced. Now, your lordship, Supreme Court has said that these things cannot be taken into account because these things will be considered by the trial court, your lordship. These things will be considered by the trial court after recording evidence, cross-examinations, and there will be argument, your lordship, there will be issues, your lordship, and it will be decided by the trial court whether the contract is to be, is not to be enforced or the specific performance of the contract is to be refused. If it is refused, your lordship, the court will pass a decree to the that I am not entitled to get the relief of specific performance of the contract because of such and such provisions in the section 14, your lordship. But the Supreme Court said, your lordship, roving inquiry or investigation is not permissible. So for section order 7, rule 11 is concerned, your lordship, detailed investigation or navigation is not necessary. So it must be manifest. It must be manifest, your lordship, from the pleadings, from the statements made in the plaint itself, and not otherwise, your lordship. Now, from the plaint, your lordship, forgetting everything, your lordship, no plea, nothing of that sort, your lordship. Whether such a statement is here in the plaint, your lordship, that this is the plaint, this is the statement, averment, your lordship, and on the basis of that, the suit is not the suit, your lordship, specific performance is not permitted. Now, your lordship, there are decisions that there can be no partial, there cannot be any partial rejection of the plaint. There cannot be, if it is to be rejected, your lordship, it must be rejected, your lordship, in toto, not in part, nor partially, your lordship. Now, here in this case, as I have already submitted, if supposing a specific performance is not given, your lordship, that does not mean, your lordship, that I am not entitled to get refund. There are some reply in the notices, your lordship, in the records, that I have assured, your lordship, that you take back your money, I am ready to pay. The predecessor or the present predecessor, he assured also that you take back your money, I am ready to, but I will not get it executed because I will get it executed through some other agent, not by me. I am not pleased with it. So that is his version in the reply. So those things are there that will be proved before the trial court. Now question is, your lordship, when there is twofold of relief actually we have claimed, one specific purpose of the contract in failure, your lordship, this is refund of the refund of the amount. Now it is combined in the suit, your lordship, and the Supreme Court says that there cannot be partial rejection of the claim. There cannot be partial rejection, and there cannot be roving investigation or inquiry, your lordship, for finding out whether the claim can be rejected, your lordship, under order 7, rule 11. In this regard, your lordship, I'd like to place one. Good evening, sir. Lordship, condition is, your lordship, 2022 7 SCC 731, paragraph 7, your lordship. Seven. Now, Now, so far as the issue whether the suit can be said to be barred by limitation or not at this stage, what is required to be considered is the averments in the plaint. Only in the case where on the face of it, it is seen that the suit is barred by limitation, then and then only a plaint can be rejected under Order 7, Rule 11B, CPC on the ground of limitation. At this stage, what is required to be considered is the averments in the plaint. Not the argument, your lordship, not the picking up of some provisions from the act, your lordship, or by argument, your lordship, it cannot be improved. In the plaint, for the aforesaid purpose, the court has to consider and read the averments in the plaint as a whole. As observed and held by this court in so and so, rejection of a plaint under Order 7, Rule 11D CPC by reading only few lines and passages and ignoring the other relevant parts of the plaint is impartial. Is impartial in the state decision in para so and so, it is observed and held as on that. As observed earlier, before passing an order in an application filed for rejection of the plaint under Order 7 Rule 11D, it is but proper to verify the entire plaint averment. The aforementioned materials clearly show that the decree passed in the suit so and so came to the knowledge of the plaintiff so and so, so and so, so and so, as filed in the copy of the earlier decree, was placed on record and hereafter.
Taking your point.
Lordship. Now your lordship will come to the para 10, your lordship.
We take your point. We take your point.
Lordship, one sentence just I am reading, your lordship. Para 10, your lordship, last sentence. Para 10, last sentence, your lordship. If that be so, the suit for decree for permanent injunction cannot be said to be barred by limitation. It is a settled proposition of law that the plaint cannot be rejected per se. So on that, your lordship, other decisions are also there, your lordship, Supreme Court the party here. Supreme Court. Lordship, this is 2015 8 SCC 331, paragraph 5, 6, 9, and 11. I'm reading paragraph 5, your lordship. Rejection of plaint under Order 7 Rule 11 CPC is a juristic power conferred in the court to terminate a civil action on the threshold. The condition precedent to exercise the power under Order 7 Rule 11 therefore are stringent and have been consistently held to be so by the court. It is the averments in the plaint that have to be read as a whole to find out whether it discloses a cause of action or whether the suit is barred under any law. At the stage of exercising power under Order 7 Rule 11, the stand of the defendant in the written statement or in the application for rejection of the plaint is wholly immaterial. It is only if the averments in the plaint expressly do not disclose cause of action or on a reading thereof, the suit appears to be barred under any law. The plaint can be rejected. In all other situations, the claims will have to be adjudicated in the course of the trial. 6. In the present case, reading the plaint as a whole and the proceedings on the basis that the averments made therein are correct, which is what the court is required to do. It cannot be said that the said pleadings, ex specie, your lordship, disclose that the suit is barred by limitation or is barred under any other provisions of the law. The claim of the plaintiff with regard to the knowledge of the essential fact giving rise to the cause of action is pleaded will have to be accepted as correct. At the stage of consideration of the application under Order 7 Rule 11, the stand of the defendant in the statement would be altogether irrelevant. Now, your lordship, the other paragraphs, your lordship will go through, your lordship, 9 and 10. Lordship, this is 2016 to GLP 1041, paragraph 23-24, your lordship.
Yes.
22. The pleadings in the plaint as noticed above demonstrates series of causes of action against the defendant. The submission made by the learned counsel for the petitioner that the documents relied upon by the petitioners are per se illegal and therefore cannot form the basis of cause of action cannot be accepted. The court is not required at this stage to make a detailed inquiry. Detailed inquiry is not necessary. It is also not permissible to brand a document as illegal or void before adjudication is made. That it had been held in so that it is a settled legal proposition that even if an order is void, it is required to be set aside by the competent court of law or to be so declared by a competent forum, and it is not permissible for any person to ignore the same merely because it is in his opinion the order is void. This court is also unable to accept submission of Mr. Swencho that the substratum of the plaintiff's case being illegal issuance of patra to such and such on the basis of order dated Swencho, seeking a declaration that the deed of gift Swencho is misconceived and same cannot be construed to provide a cause of action for filing this suit. It is not in dispute that there is in existence a registered deed of gift. Here in this case, registered deed of development lordship involving part of the suit property, and therefore the plaintiff would be entitled to seek declaration that the gift deed is null and void in the instant suit, as otherwise it may lead to multiplicity of proceedings, your lordship. Now 23, in view of the aforesaid discussed the contents of the petitioner that the plaint is liable to be rejected, censure is not tenable in law. 24, in terms of section 9 of CPC, the civil courts have jurisdiction to try all suits of civil nature, excepting suits in respect of which cognizance is either expressly or implied debarred. The jurisdiction of the civil court should not be readily inferred, but such exclusion must either be explicitly expressed or clearly implied. It is a settled principle of law that even if jurisdiction is excluded, the civil courts have jurisdiction to examine cases where the provisions of a particular statute have not been complied with or where the statutory tribunals have not acted in conformity with the fundamental principles of judicial procedural law. So, throw light upon the case, Your Lordship, that the objection raised, Your Lordship, that cannot be decided under Order 7 Rule 11, but it is up to the trial court. Trial court decide, Your Lordship, after taking or recording evidence, cross-examinations, and thereafter, Your Lordship, court will decide on the basis of the law as well as the recorded evidence. And the decisions of the Supreme Court is decided. It is 2018 11 SCC 780, Your Lordship. Supreme Court, Your Lordship. Segal Glass Limited versus Nabilan Marshals Private Limited. From Manupatra, Your Lordship. There are 7 and 10. Seven, Your Lordship, and got it, Lordship. In the Supreme Court of India, that is, it is referred as 2018 11 SCC 780. I have marked above, Your Lordship. What you got it? Yes, yes. Got it. Similarly, in Panchilal versus Swaincho, the High Court held, but the real question which arises in this appeal is whether there can be a partial rejection of the plaint. Mr. Chiranjeev Lal Agarwala submits that a plaint can either be rejected as a whole or not at all.
Don't read the reference part. Come to paragraph 10.
We are afraid that this is misreading of the Madras High Court judgment. It was only on the peculiar facts that the case is that one of section 80 CPC against the defendant led to rejection of the plaint as a whole, as no cause of action would remain against the other defendant. This cannot elevate itself to a rule of law that once a part of a plaint cannot proceed, the other part also cannot proceed. And the plaint as a whole must be rejected under Order 7 Rule 11 in all cases. If the plaint survives against certain defendants and or properties, the Order 7 Rule 11 will have no application at all, and the suit as a whole must then proceed to trial. So it is a case, Your Lordship, where there are a number of causes of action that the agreement for development it subsists, that should be declared. Cancellation of the general power of attorney, your lordship, which is irrevocable, your lordship. And my interest has been drawn over district property by a payment of rupees 22 lakhs, your lordship. The second one, your lordship, is a refund of the amount. Now, your lordship will find 2022 GLT ML 742, paragraph 8, 9. 9, I'm reading, your lordship. Coming now to another argument whether the plaintiff in the present case does not disclose any cause of action and therefore should have been returned and the suit dismissed in view of the provisions of Order 7 Rule 11 CPC. The Supreme Court in such and such, para 13 of the report expounded the meaning of the cause of action in the following words. While scrutinizing the plaintiff averments, it is the bounden duty of the trial court to ascertain the materials for cause of action. The cause of action is a bundle of facts which, taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree should be set in clear terms. It is worthwhile to find out the meaning of the word cause of action. A cause of action must include some acts done by the defendant in the absence of such an act. No cause of action can possibly accrue. The Supreme Court in such and such in paragraph 12 explain the meaning of cause of action in the following words. A cause of action means every fact which, if reversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is bundle of facts which, taken with law applicable to them, gives the plaintiff a right to relief against the defendant. It must include some acts done by the defendant, since in the absence of such an act, no cause of action can possibly accrue. It is not limited to the actual infringement of the right sued on, but includes all material facts on which it is founded. It does not comprise evidence necessary to prove suspects, but every fact necessary for the plaintiff to prove to enable him to obtain a victory. Everything which, if proof, would give the defendant a right to immediate judgment must be part of the cause of action, but it has no relation whatever to the defense which may be set up by the defendant nor does. It depends upon the character of the relief prayed for by the plaintiff. So whatever relief I have prayed for, your lordship, it will depend, your lordship, whether there is a case to go for the trial to the last moment. Now, this cause of actions, your lordship, I have stated in paragraph, your lordship will find that is.
You stated many things. Stated while starting that you take 15 minutes.
Lordship.
Those things, need to repeat it again. Wait for Mr. Kulji to come and give his reply.
That the cause of action for the suit arose on 27/5/2018, when the possession of the land was not delivered to. So, your lordship, there are number of possession action, and on the basis of that, your lordship, number of reliefs have also been claimed. And alternatively, your lordship, there is a relief claim for the refund of the money also, your lordship. Now, the both the things cannot be bifurcated. There can be a partial rejection. Anyway, your lordship, this is my humble submissions, and I think, your lordship, these decisions and so far the appointment pending to plaint. There is no case for rejection of the plaint under order 7/11, your lordship. And the petition is very critical, that nothing has been shown. And why the plaint is to be rejected, and what are the amendments or statements, your lordship, that because of this, there is no cause of action, or because of this, the suit is barred by limitation.
Wait for some time. Judicial coordination. That's fine.
Yeah, so other fees matters.
No, no, it has to be closed then. It has to wait for some time.
Lordship, I'm appealing for the respondent husband, your lordship. The transfer petition, your lordship, for transfer of the divorce case pending in the in the court of the district judge Dibrugarh to Golaghat, your lordship.
You are waiting to be there.
Lordship.
On what ground?
Lordship, actually, lordship is here the matter petition. Lordship,
I'm still hearing you.
no, lordship, on the, lordship, the petitioner and the respondent are separated for 10 years. Their marriage solemnized in 2014, and in 2016, a girl child was born to them. And after the birth of the girl child, the petitioner went to her maternal home to come back after a few days. But after going to her parental home, she refused to return and asked the respondent only to arrange for a separate house.
Those things are okay, but how you are, so why you are opposing this?
No, sir, actually, there was in Golaghat, there was a domestic violence case and a maintenance case filed by the petitioner. And the respondent has traveled all along from Dibrugarh to Golaghat to fight these cases, and these cases are now disposed of. Now she has again, so if this case is transferred to Golaghat, your lordship, he has to come once again traveling from Dibrugarh to Golaghat, your lordship. He has
Not
a
very far.
ailing mother,
Not very far.
4.5 hours, your lordship.
See, there's nothing on record to show that you are paying maintenance.
Lordship.
He says that he has no money.
And moreover, some mutual talk is going on, your lordship. Maybe they are
Transfer the matter.
lordship, maybe that's why they are not appearing, pressing for the matter, your lordship. Maybe.
She's poor, she can't pay, and therefore there's nobody to come for her.
But this is represented by an advocate.
But we can't do anything. The law is not there. That means they presume that he is not in.
Maybe they are not pressing also.
Then they will not press it before the court. They are not coming means there are no instructions.
Maybe.
No instructions means the financial condition of the petitioner would be very bad.
That's it. If there some mutual talk is going on, then
That can be done by mediation in that court, the transfer court. If you are, see, who benefits out of this litigation? The petitioner who has come here, he's 28 years. That is for 10 years, they are living separately. He was 18 now, and now he's 28. And what is the age of the husband? It could also be 2-5 years here and there. Maybe. He's 38 years. There's a delay of 40 lakhs.
Actually, what happened, the husband has suffered an accident in 2018, Your Lordship. He has this spondylitis and also he is restricted by doctors also to travel. And he.
Don't tell us that. Don't tell us that. If there's a doctor who can say that, we won't accept that doctor's statement. I have all these problems. I have slipped this L3, L4, L5, I have spondylitis, I have all other bone-related ailments because of my sitting posture. I traveled a lot.
No, Lordship, they can also opt for some other place in between both of them.
No. It can't be. If a wife can travel 20 kilometers, she can travel 200 kilometers.
Lordship, actually, Lordship, kindly can see that the wife is a resident of Dergaon, Your Lordship. From Dergaon, she has to come for nearly.
Is there a family court or?
No, it is going on, district court is in Golaghat, Your Lordship. So it is half hour to Golaghat. And if she comes to Jorhat also, it is half an hour. So if the matter is transferred to Jorhat also, the 1 hour of the respondent will be saved, Your Lordship.
No. It's not a correct.
So the time will be same for the petitioner.
Not everything that time. The resident of the particular district.
From Dergaon, both Golaghat and Jorhat will be of the same distance, Your Lordship. If it is transferred to Jorhat, 1 hour of the respondent will be saved, Your Lordship. It is 3.5 kilometers to Jorhat.
These matters are multiple cases, you can't do it. And in this transport petition, you can't impose a cost. Otherwise, we would have told you to give the start the rental now. You can't do that in transport.
But a place of agreement
You
can.
can always exercise the jurisdiction to, what do you call the court's power to, detain your case on video conferencing. How do you sort out? Nowadays, everything is connected to video conferencing.
That's true.
These are matrimonial matters are to be taken in the chambers. We just have to accommodate to make up.
But a place of.
You need to contest the proceeding. How many dates you want in a matrimonial case for divorce? You're not taking 100 dates.
But if a place of agreement is there between the two parties, Your Lordship, it would have been better, Your Lordship.
We understand. You see, 24, this case was filed. 24, now we are 26. This attempt was never made.
Because traveling to Jorhat and Golaghat will be same, Your Lordship. The distance is nearly same, time will be nearly same. In any case, the petitioner will have to travel. Either it is Jorhat or Golaghat.
Not a consideration. He said it's convenient for her to appear in a particular place. Can we substitute?
Well, then let the matter may be sorted out between them, Your Lordship.
They are not there.
But they are communicating, actually.
No. The lawyers of the plaintiff have withdrawn. Somebody came and told us that we will appear for the wedding. Nobody appeared. This demonstrates that he has financial disability. Otherwise, no lawyer will not appear for a client. She says that she is unemployed. And There's nobody in the home to sit for traveling.
But the respondent was willing to
Are you
take
willing
her.
to pay 10,000 rupees for each travel to the lady in advance? We retain the case wherever it is. We say that you pay 10,000 and deposit the money in advance for the date for you to come, the wife to come. Difficulty. Can't force it in a, people transfer between to pay cost. Not a jurisdiction. But it has to be done. Some reasons for the different power. Okay, right, content. Taking transfer of the divorce suit, entered as TS within bracket D, bracket close case number 63 of 2023, from the court of Gauhati district judge from Aditya to the court of Gauhati district judge from Kolkata. The in this application, it is projected that the parties have a girl child born to the petitioner on 21/1/2016. Okay, feels that there is the petitioner has filed the domestic violence case against the respondent before the court of Chief Judicial Kolkata, and separate application under section 125 for the girl child and the herself. Petitioner has received summons for appearance in the event. He has no income and no one to accompany her to deliver to contest it. It takes 6 hours. Clearly, go and turn back. Take for the transfer of the court to district judge, court of district is learned district judge Kolkata. The home district of the petition. One child, 8 years, studying in class 2. The no one should take care of her. Travel to school. Next, the first part of the learned doctor to respondent. So that after it's false. The petitioner is a resident of their town and travel. In travel. Long distance to go to district headquarters at Kolkata. So, accordingly, to be transferred to Kolkata. Same travel time. both sides. It's not include that. The is taking care of the girl child born on 21/1/2003. For that. The minor child studying and the application was filed on 16/2/2024 on the minor child was studying class 2. That's very long. So this concept the earlier set of concept has gone and the new set of concept has the appearance of the law. Concept is again from Bahama 25 to 2026. But set off for the key from the battle of the instead of the price to be given protection. comparative distance of one foot of one district. Foot of another district. Trying to provide that. Of the records. Run it. It is not dependent. English to see. It's a like clearly that might be for something. Done to for the field. Of the photo
Obligation.
My lord, I sincerely apologize for not being present. My lord, I had been in the, my lord. Now, my lord, I am given to understand, my lord, my opponent has completed his argument.
Not opponent. Is that opponent?
Yes, my lord.
No, no, he addressed you as a good friend.
In fact, my lord, friends and brothers, my lord, they are the best friends and they are the, my lord, worst enemies also. When they become enemies, they become the worst.
I don't know.
That we have found upon brothers, my lord, when brothers fight.
Good friend.
No, in fact, my lord, I had made my submissions mostly, my lord. Some points are late that I can address your lordship if your lordship permits me today or any other day whenever you permit me.
It's very difficult.
Yes.
Hearings are fighting now.
My lord. So I'll try to be as brief as possible, my lord, but then, my lord, I have to cover the points. In fact, my lord, the application for rejection of claim was filed by me on, my lord, primarily 4 grounds. Those grounds are, my lord, firstly, the representative of the plaintiff who had instituted the suit, he doesn't have any locus to file the suit. Because, my lord, in the plaint, he has not produced any document to show that he has been authorized by the company. No resolution of the company has been, my lord, annexed. And the plaintiff company registration certificate has also not been produced. And, my lord, since there was no resolution of the company which has been produced with the claim, on that ground alone, my lord, the suit is not maintainable and the plaintiff was liable to be rejected. That was the first one, my lord, I have taken in my application for rejection of claim. My lord.
I can come to page 45.
My lord. Registration number has been given. My
No,
lord.
no, no. Even his name, managing director, Mr. Mohammed Karim Ahmed,
My lord.
and he has signed as that. Once you to his authority, that not be permissible for you to come back and say that you don't know BC.
And attorneys, etc. My lord, that will include, my lord, his attorneys as well. Your lordship is referring to the second paragraph, my
No,
lord.
no, page 45, second paragraph.
My lord.
He gives his name as managing director.
My lord.
And you see, when you are entering into an agreement,
My lord.
there's a presumption that you will have done the due diligence.
Yes.
And you were aware of this, therefore you gave him this power attorney, you gave him this agreement. Now you can't possibly be allowed to come back and say that you don't know who this person is. Challenging the locus standi to file a suit.
No, but then, my lord, so far as this filing of the suit is concerned, now, my lord, it has to be a, my lord, self-contained petition, my lord. That does not include the, my lord, registration certificate or, my lord, the authorization that this gentleman has been authorized by the company to file the suit. Entering the agreement is one aspect. I had entered, my lord. My predecessor has entered. But then, my lord, so far the filing of the suit is concerned, my lord, he has to follow the requirement of law. That was my first point, my lord. My second point was that, my lord, specific performance cannot be given as per section 14 as compensation is money would be adequate. That, my lord, I have argued the other day. I will not, my lord, take your lordship's time. Section 14, your lordship is very much aware, my lord. Now, the fact remains, my lord, that some advance was paid. In respect of the 2 agreements, certain amounts were paid. And, my lord, we are ready and willing to do that, my lord. So, if that part is, my lord, agreed by us, there is no reason, my lord, why this suit should continue. And, my lord, why my lord, the prayer regarding compensation and damages, liquidated damages, those are, my lord, will not be relevant at all. Thirdly, my lord, section 14(3)(c), your lordship has, my lord, elaborately dealt with that. Now, my lord, the
attention of the trial court in passing the impugned order was on the, my lord, 3C. Point 3, Roman 3, but then, my lord, it appears, my lord, the totality of the, my lord, section has not been understood by the trial court. If I may read the, my lord, that provision once again, my lord, at the cost of repetition, because, my lord, this is the, my lord, strongest point I have, my lord, in my favor. That pre-amended provision, my lord. Because there is no dispute, my lord, that the pre-amended amendment provision will.
For other members of the bar, I do not have time to take up any of the matter. Let me go.
This may go, my lord, that is one sentence everyone, my lord, longs to hear after 2:30, my lord. Everyone in the. That is what, my lord, we used to hear from Justice James Saram, my lord, please remember for that. How we long to hear that, my lord.
That's why I do it. Times when I can't take up the matter.
No, my lord, while reading, my lord, there is no dispute that, my lord, the pre-amended provision will be applicable here because of the date of the amendment and the, my lord, date of the agreement. That I need not repeat, my lord. Then, my lord, section 14, it starts with, my lord, contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely, then, my lord, these provisions have been stated. While reading clause C3, it appears, my lord, the trial court has, my lord, ignored the first sentence, my lord, the following contracts which cannot be specifically enforced, and concentrated on, my lord, the subclauses of clause C, where the suit is for enforcement of a contract for construction of any building or the execution of any work on land, provided that following conditions shall be fulfilled. It means, my lord, where the suit is for enforcement of a contract for construction of any building, the suit is not maintainable, provided, my lord, these conditions are fulfilled, namely the building or the work described in the contract term sufficiently precise to enable the court to determine the exact nature of the building or work. And for that, my lord, I have to refer to the, my lord, the clauses of the agreement, which will show that it is very vague. There is no clarity, my lord, what will be done. My lord, the agreement says there will be building. What building? It says, my lord, the partly commercial, partly residential. How many floors will be there? What will be the ratio of the, my lord, owner and the, my lord, developer? These are not stated, my lord. It says that so many percentage you will get. So many percentage in which floor? If, my lord, these are not there, then, my lord, even if a decree is passed, that cannot be executed. And therefore, a suit, which, my lord, the suit, if the decree is passed, it cannot be executed, then, my lord, that suit is not maintainable. That cannot be, my lord, entertained. And the second provision, my lord, that the plaintiff has a subsequent interest in performing the contract, and interest is of such nature that compensation in money for non-performance of the contract is not adequate relief. Here, my lord, what I have done is, my lord, by virtue of the agreement, he has parted with some money, which I have accepted, which I am ready to, my lord, refund to him. And that, my lord, that can be, my lord, enforced at any point of time. And in fact, my lord, there was proposal, my lord, that you take the money back. But then, my lord, they filed the suit. Now, my lord, this was my second point. Third point, my lord. Now, my lord, I'll also, my lord, have to point out your lordship, my lord, about the vagueness of the agreement, my lord. It does not specify, my lord, what type of construction will be there, what will be the square feet, what will be the commercial area, what will be the
residential area, to what extent and which floor and which specifics, my lord, the particular the builder will get and the, my lord, landowner will get. Therefore, this is not aggregated. Now, my lord, one more important thing is, my lord, this is also barred by section 29 of the Contracts Act. Why I say this, my lord? If your lordship kindly takes up section 29 of the Contract Act. No, my lord. Agreements, the meaning of which is not certain or capable of being made certain are void. Therefore, my lord, the uncertainty, which is, my lord, evident on a plain reading of the agreements, makes the, my lord, the agreement void. Now, I'd like to draw your lordship's attention to page 154, where the plaintiff filed an objection. Please, 154, your lordship may kindly come. That is a part of the, my lord, objection filed by the plaintiff against my application. It starts at, my lord, page 151. That is the objection, and I will be referring to only one paragraph, paragraph 8 at page 154. May I read that, my lord? That the statements made in paragraph 5 of the application are misconceived, baseless, and motivated, and as such denied by the plaintiff. If in the contract terms are not specific or vague, the same can be made specific by subsequent agreement or addendum. The present development agreement can be supplemented by incorporation of fresh terms and conditions or by modification and alteration of the existing terms and conditions, which is permissible law. The present suit is basically for handing over possession of the suit land to the plaintiff so that follow-up action as can be taken for further development. The defendants misconceived the suit with an arrogant attitude after realizing huge amount. Section 29 of the contract is not applicable in the midst of the cases as alleged by the defendant. Now, my lord, this paragraph is a clear admission of the fact that, my lord, the terms of the agreement are vague in nature. So, my lord, when the plaintiff himself, my lord, admits that the terms are not specific, so my allegation has been proved that it is not a specific, and therefore, my lord, which is not specific, then, my lord, the suit cannot be, my lord, maintainable. So there is clear, my lord, admission. Now, in the impugned order, my lord, that your lordship has read, I will not repeat, my lord. The findings at page 193 and 198, my lord, the learned trial court has failed to, my lord, go into this aspect of the matter and did not understand the, my lord, the provisions of the section 14(3)(c). Now, my lord, may I point out, my lord, the vagueness of
You see, you refer to the provisions of section 29,
my lord,
as well as page 154.
my lord.
You have referred to page 154 as well as you have referred to section 29.
My lord.
Please come to page 50. There,
My lord.
at page now C. Immediately after there is no instance for our purpose related to permission for construction. The head of both line is fine.
My lord, I did not get your worship.
Page 50,
Yes, my lord. Paragraph, a clause,
Article 3, number 3,
Article three.
Article clause 3. The landowner shall immediately after agreeing the extent of the agreement shall agree to the use of power attorney and or up to the authorized economic by terms of the purpose relating to the permission for construction of the multi-story residential commercial building in the name of from the competent authorities. Now,
My lord. Multi-story residential commercial buildings in the name of the development builder from the competent authorities and the construction of the multi-story residential building, work and construction of multi-story property for the present purpose transferring the developer.
correct.
Fine.
Therefore, can this not be read that there is a next, that both parties enter into a contract? That after this contract, we will apply for building permission. What building permission one will receive, we don't know. We get a if we have certain movement in certain circles, you may get a 50-story building permission. And if what you call the instructing council does not have it, he may get a 2-story, she may get a 2-story building permission only. So therefore, how will when we entered into a contract, you know that the agreement is not there. The building permission is not there. So therefore, the condition of an specified allotment, whichever arise, is always.
My lord, I'll differ with that, my lord. Firstly, the agreement has been entered into by a, my lord, very renowned builder. And my lord, in a particular plot of land, if we give the measurement of the land, then my lord, the law specifies, my lord, what will be the FAR. If the FAR ratio is, my lord, known, then the builder will know how many floors he can build and what will be the height. Without knowing all those, my lord, a seasoned developer does not enter into an agreement. I have got a plot of land. If I want to build a house, I'll know, my lord, that this will be my FAR, that ratio. And on the basis of that only, my lord, I'll ask my the architect to design it and, my lord, show how much floors I can have. This is not something, my lord, which can be left to the whims or, my lord, wishes of the Gauhati Municipal Corporation or Development or GMDA. These are laid down, my lord. What will be the FIR ratio? If you know the FIR, you know what storage of building will be there. And, my lord, if you give me 50%, the top floors you give me, you take all the risk. That may be possible, my lord, because the agreement doesn't say. So that is vague. That is where the vagueness lies. It's not that, my lord, the municipal authorities, they can, at their own wish, my lord, can say that no, you cannot have 8-story building, you can have only 4-story building. They cannot say that, my lord. They are also bound by my lord, the regulations they have. And my lord, the developers know it, my lord. That is how the my lord, price for the land is fixed or the ratio has been fixed. That is how it is done, my lord. There is an intent, my lord, to deceive from the very beginning. And the person, my lord, who signed, my lord, the register of the petitioners, my lord, he was a very old man. That ground also we had taken. I am not urging that because I do not say he was insane. That I do not say, but 80 plus, perhaps, is it? He was 80 plus. And he was very unhappy after the agreement was executed and he said, you take the money back. There is this facts are there because he trusted, my lord, the developer. And that's why, my lord, he has cancelled the power of attorney. So, my lord, the vagueness that cannot be cured by the fact that, my lord, since the permission of the municipal authority has not been taken, nobody knows, my lord, what will be area, my lord, square feet area of the building. And that square feet, my lord, how it can be distributed into different floors. After, my lord, complying with all the regulations by, my lord, the side margin, back margin, my lord, those margins. Everybody knows, my lord. And he is not a fresh developer. He is a very renowned developer in Gauhati. Therefore, my lord, that doubt in your lordship, my lord, does not cure this, my lord, this defect. Okay. Okay. My lord, if your lordship permits or request, I can place up decisions like that, my lord, the Honorable Supreme Court, what the Supreme Court says about Order 7 Rule 11. फोटो कॉपी तो दिया आपने ना तो ये वीडियो में चलेगा तो ये ऐसा कुछ वीडियो मैं दूसरा सब चलेगा बनाने के लिए 144 149 these are the decisions I will relying. I may not read, my lord, the provisions because I know your office is aware of all these provisions, my lord. Even then, I am relying on that. My lord. My lord. Okay. In fact, my lord, the trust that one reposes on the other, my lord, that creates all these, my lord, difficulties. This old man, my lord, he trusted him and he drafted the developer drafted it, he signed it. Thereafter, he realized that that is a mistake. So these decisions I am relying, but perhaps I need not, my lord, take your lordship's time by reading the relevant paragraphs. You know, seriously become, man. Yes, my lord. The paragraph 4. Paragraph 5 will be relevant. Paragraph 5. I'll just see, my lord, inform your lordship about the paragraph and my lord to save time. So that, my lord. Yes, my lord. My lord. Delhi development, no, I will create a wicked place, Delhi development will be controlled. Yes, my lord, Delhi Development Authority, your lordship, the relevant paragraph 18.
1993. Mayabati, my lord, paragraph 8, 18 and 22. 18, 8, 18 and 22. 22. My lord, the relevant paragraph are 23 and 24. Raghavendra, my lord, paragraph 7.
There is one more. Empty marking. Dot is something.
Where, my lord, the relevant paragraph will be paragraph 14, 1-4. Now. There is also, my lord, three bench judgment that also I would like to place, my lord. Paragraph 2022, volume 6, SCC 762. Paragraphs, my lord, 60, 61, 62. That is, my lord, English law, because this is borrowed from English law, my lord. And 67. 67 and 68. Because this, my lord, specific relief act is, my lord, that is a, my lord, English law, my lord, and the interpretation was also, my lord, English before that, and that's why, my lord, the landlord, the builder could not have filed the suit earlier. Then, my lord, the Honorable Justice, the Justice Chandrachud in his judgment, my lord, made these modifications because of which the amendment has come. That, my lord, protects the interests of the builders.
Then you find this fact which is the key.
My lord.
That thing. That was legal. New books, this new books that original section is not there. Because this was deleted long back. It was deleted. By repealing act of 1938.
38, my lord.
Therefore, old books get in the library, old books of 70s, you can get the text exactly. That is not available. I got some old books from the library and I found them. So this is the second two is that the British laws of the that was recent.
But that has not been quoted here, my lord, the Judicial provision.
Not very. And only say if you get a dividend back of 70s onwards or something like that.
I just must have got it, my lord.
No, I library had, so I got it from there. I get it from, show you some titles. There is, this was with the effect of the petition is that the Indian laws became paramount. And therefore, as a student of law, nobody teaches me has been laws of India. We are not trained in laws. If you can have, you must have this, you have husband laws in your family. It's such a modern thing, the old volume, volume 3, has that common law principle. To start reading it, I don't know about you, in fact, I'm thinking of myself, when I started reading it, there is so much annotations and then references down below. Every point against, there's so many references down below that by the time you start reading it, forget what you were, originally what you were reading.
Okay.
I have tried many times, petitions to read that and to understand what is the concept of this form. Now, before for the paramount, there are saying that common law we applied in India. Including that Shah and all proposition disease only for me. What is that common law we have? So this is why I'm asking. If I'm not trained in that law, how can I assess the court? For you, how can you assess the court in that?
True, my lord, very true, very true.
Common law. And how will I in discussion of justice apply that law?
Yes. My lord.
But
And-
see, I'll be treating you unequally. If I borrow the principle from some English book and then I impose it on the case that is being argued by you.
Then, my lord, I'll not be able, in a position to answer that much.
Not be the point to answer that unless we're failing law.
Yes.
Therefore, especially here and there, I thought of book cannot be trying to explain this concept.
My lord, that's true.
How it can be applied because there's a damage to be, you say that thought will apply and damages common property. What are that principles? The context of compensation. You get the husband laws. I think in one very hard to remember what they intend to say.
And my lord, those laws, my lord, or the decision subsequently, my lord. In a particular case, my lord, on the facts of that case, whether this principle applies or not, that is another aspect to be, my lord.
It's not bad. I'm just asking that the spirit of law,
My lord,
not to apply that to this case.
my lord.
Learning at this stage also that how do we apply this? What is the parameters to what extent can be adopted? So, what are the things about that? So, when there is a act of damage, electricity, what is called, road accident and all. When you say that the common law principles apply, before you take it, it says that palliative.
Palliative.
That means if only a total compensation Then bring it in court. Then, second time, there is a dispute which says that not only penalty, but I'm expecting in six. And Article 42, you can apply Sarla Varma and then say you pay this much. Then there's a case of Delhi. Part validity, it says that we do this and therefore we take a compensation. It's not people die in school in before compensation. That was given. Other judgments follow that, but that principle also given as principle. That part, there's a nomination somehow operating common law. Then it will say that no, Sarla Varma will follow. Before multiplier, this one multiplier, this will be part of the amount and the level. The lab systems which say the other. The quality part never considered. Then people borrowed from that by the
In fact, my lord, my learned friend was finding out some, my lord, the laws on this, my lord, the compensation part, because one part I was worried that why you have asked for damages, how can you overcome that? So she was finding out some case, so I said, if we place all this report will be annulled, forget it.
that is the so I have to go before I.
But then if you lost it, my lord, no, my lord, on this, my lord, regarding that, the part of the refund of the money and my lord, the compensation part. If you lost it, permission, my lord, I may give some, my lord, cases of the, my lord, common university.
Right.
My lord.
Not there for refund.
My lord, that will support me to some extent, my lord, that's why.
But that argument of yours may not be not be acceptable for a different reason. I think exercise law, religion law, not a degree on admission. To make that what applies it.
That is right, my lord.
That's the yeah, ask to have a religion done.
That is what, my lord, we were discussing, me and my learned opponent, my lord, we were discussing. He said, he also suggested his client that why don't you take the amount with some interest? So that is possible. now.
But that,
Yes, yes, my lord.
why do we give it for orders? Can have it something.
No, yes, my lord. Yes, we were discussing that, my lord, the other day. I think my learned friend was also there. He said that he was advising his client because this will take a very long time. My lord. Then, my lord,
On attempt to get the
yes, my lord.
right now different.
My lord.
Passing to approve the order is the same as accordingly.
Yes, my lord. Yes, ma'am. Yes, ma'am. Why not to that effect, the date may be fixed, my lord? Yes, yes, yes. Tomorrow we can just talk to his client and. Yes, yes, ma'am. Ma'am. That will be great, ma'am. I'm grateful. Yes, ma'am. Because the mediation should take only 1 day. But then so far as the arguments are concerned, madam, these are concluded. Yes. My lord, I'm sure my name is recorded. So will you inform at 10:30, my lord? My lord, one decision I just left by mistake, my lord. Your lordship may kindly take on record. That is my 2019 PSSC 241, Kushal Kumar Agarwal. My lord, the paragraphs are, my lord, several, 11, 13, 11, 13, 14, 16, 25, 27, 29, 30 and 31. In fact, my lord, this is the basis, my lord, on which I had made my submissions, my lord. This I'm sorry, my lord, I just missed. My lord, I apologize again for not being present at the, my lord, and my lord, grateful to your lordship for accommodating me. Yes. The lawyers must be very unhappy, right? But then, my lord, at the same time, taking so much pressure also tells upon the table. That aspect, one has to